I think we're finally good to go.
Those pens. Thanks.
Okay. All right, everybody. Let's see. Today is June 25th, 2026, and the board is going to open the hearing on the decision for Ricketts Pond's 40B application. Now the public hearing is closed, so therefore any further public comment is not permitted. So anyway, so today the board has a draft decision prepared by town council along with a list of waivers. That decision's been updated as of this morning, and we will be considering that and going through and any questions that need to be raised by members of the board, shall be considered. We will review the documents, and we will we will discuss it among ourselves. Now, the only people who have a right to participate in this proceeding is people who are sitting to my left and right. Everyone else only can speak by leave of the chair. So anyway, so with that, let's see. So we have. So I think we should turn our attention to the main decision draft and start from there.
And there were changes made.
Yes, all right, so we have, all right, so
I'll highlight those.
let me just make sure I've got the most current one here.
Oh, did you send the most current one?
Most current one was sent somewhere around 11 o'clock this morning.
Okay, all
Okay,
right.
so I can look at
Or
that.
just before that.
And I have 1052 was Carolyn's last
Yep.
email. It was incorporating some changes Mr. McKenzie suggested.
Yes.
All right, so we're going to use that one.
Did we highlight them by any chance?
It's either redlined or highlighted,
Okay.
mostly redlined for those.
And there's also an earlier list of waivers, which has to be addressed too. Let's see, let's see the email that. Okay. Okay, where is the list of waivers?
It's in one of the
That
emails.
was attached on the, you didn't send another one, I don't think. That would be June 12th.
No,
No,
she sent
the
out some.
revised, the revised waivers would have been earlier this morning, maybe around,
Okay, I have
Or 10 or so?
I have 1022 appears to be the waiver list. So anyway, so we'll base that off. We'll base our decision our consideration decision today, if any, on that. Okay, all right, so okay. Okay, now, all right, so now, and just for purposes of the record, the people who are going to be voting on this will be myself, Suzanne Jafarian, and Dave Alberti to my left and right. All right, so, okay, all right, so on the screen, we have the draft decision here, and, okay, and it looks good. Does anyone have any comments they'd like to make generally before we go into the actual meat of the decision itself?
Can somebody from the public make a statement?
Nope.
no.
I thought your email said they could, if they address the chair and blah, blah. No, okay.
The public hearing has been closed, so nothing new can come in from the public.
Okay.
All right, so. All right, so let us scroll down to page 3 where it talks about factual background here. And so I should start this. Let's go through this in sections here. Let's see. Okay, I think, yours looks different from how this says the thing, project
Just-
different than mine.
It should be the same.
What
Maybe I could.
What
it's just
program
a-
are you using?
Did you get the one from today? Did he open the one from today?
I think so.
Yeah, they weren't, they were titled the same, but there was no revision, so I guess maybe I have the
No,
wrong
there,
one.
if you go to the very, very top,
Yep. Page
you should have a date, and that is the most recent version, right there.
626, 625, 26.
Right.
Mine doesn't have the red. Is that right?
Yeah, I mean, it looks different depending on what program you open it.
Yeah,
and how
maybe it's
they
the
cha-
format.
How the changes are shown.
Okay.
Let's see.
Would you say page 6?
Because mine looks like yours, but it's fine.
Let's see.
Yeah, I don't have
I think
the
I'm opening
red.
this in some kind of cut-down version of Microsoft Office.
At least it's there.
But anyway, we can follow.
We can follow along. Yep.
Okay, so now, let's see, the change highlighted in yellow that starts with approximately 1.5 acres, was that something, does anyone recall who added that?
That came in from the applicant.
All right.
Oh, so sorry. I'm losing it.
Okay.
There it
We
is.
added that whole sentence there. Oh, yeah, because you underlined it.
Right.
Do we have anything to suggest that that's inaccurate?
No.
All right. Okay, all right. All right, so that looks to be part one factual background. That appears to be, I don't see anything in here worthy of comment. This all seems to be factually accurate. So I think we can move on to the next section, which is procedural history. Let's see, all right. That's, again, the procedural history was, appears to be diligently tracked by, and I don't see anything in here that requires comment. I don't see any changes. All right, okay. All right, the submittals, the next section, that deals with all the paperwork and filing that's been submitted to the board, and there's a whole table devoted to it in the building department for all the various plans and revisions to them, and other things that have been submitted in paper format. There's also been many emails and electronic files as well. But this appears to be reasonably comprehensive. I mean, has it incorporated every single document? Probably not. But does it incorporate the most important ones? I would think it does. I mean, obviously, the most important thing is the actual current plan that we've had before us. The most recent revision that's been submitted to us with all the plans.
6, I think it is, yeah.
So anyways, however, we do our best here, but there's a lot of documents that have come in from many sources. But anyway, this appears to be reasonably comprehensive as to what the record in this case has been. Okay, all right, so,
Yeah, I get the same thing.
okay, all right, so,
Traffic study.
all right, so unless anyone suggests that there's something in here that's missing, then I suggest we can go on to part 4, the findings of fact.
Can I just ask a quick question on the top of page 7 now? It just says that the strain that talks about wells and septic and the strain that the septic systems would place on the town's health department personnel. I was just curious, how would it put a strain on the health?
Oh, I think we'll be dealing with that in a little bit.
Okay.
But essentially, that's just a summary of what the document actually said.
Okay. Okay. Because I was like, if they're taking care of these things themselves, and then the people who live there will be taking care of them, I just was curious.
Oh, no,
why
that'll be
it would.
addressed further in the decision about who's responsible for what.
Okay.
All right,
Okay.
so now the findings of fact, let's see, now these findings, again, are something that's required to be put in a comprehensive permit decision. And I made a few changes or additions to part 4. which, it starts at number 3. And, and it simply acknowledges what our function is, and even though there may be some less agreeable aspects to the function, nonetheless, the facts are what they are.
Mr. Chair, could I just add to that? The revisions here more or less track your revisions. I did modify them a little bit.
Yes, I did. But that's, yes, but that's the only contribution I personally made to the,
Okay.
Between 4 and 5, those are the contributions I personally made. But,
Okay.
but I did flesh out number 4 into that, about various concerns or that the community expressed, which you'll see down there.
You know, next.
So let's see, sort of at number 5.
Yeah, it's different, isn't it?
Okay, so, anyway, so if you scroll down to the next page, all right. Now, the decision, as I understand it, has a choice, gives the board will grant a choice between, essentially is or is not, or grants or denies. That's the choice we make if we approve or deny this decision. So ultimately, the word that will be chosen will be the one that reflects the board's decision. All right. Again, the decision, essentially that says, is this permit granted, and if not, and then we go to the conditions, which comprise the rest of the document, and then the waivers, which follow. So, all right, so anyway, so we'll circle back to the decision once we've gone through the remainder of the conditions and the waivers. And if any alterations, modifications need to be dealt with, we'll do those, and then we'll circle back to whether we approve or disapprove of what's before us. Okay. All right, so now we're on Part 6, which is conditions of approval.
Part 6, what did I miss? What page is that?
Let's see.
The pages should be the
I'm
same.
on page 10.
All right, there's 11.
So you're a little ahead.
Oh, I just kept scrolling, I didn't know where you were. 10?
Yeah.
Yeah, there's 10.
Scroll up just a little more.
Yeah,
All right.
administrative. You must have an admin piece, yeah.
Yeah, all right, so, just like, can you do just one more line?
Yeah,
That other way.
up this way.
Yeah, all right, there,
Okay,
that's good.
sorry.
All right, so just so that people can follow along with what we're
Yeah.
doing here, because I know the applicant has a copy of, but I don't think any other member of the public does. All right, so, anyway, so conditions of approval, there are several sections here, and, essentially it goes from administrative to housing to plans to construction, et cetera, et cetera. We'll make sure that we follow along here. But anyway, but the document is 34 pages, we're on page 10. So anyway, so we've got a fair bit of ground to cover. All right. So, Now, I do have a question for our town council. It's part 2, it says, number 2, it says, "The board shall have the power to modify or amend the terms, conditions, comprehensive permit on the applicant or on its own motion." All right, so essentially, this looks like we can use number 2 to correct errors of form, but not of substance, is that correct?
Correct.
All right. All right, so if anyone says, hey, this looks like an error, this is supposed to be 60 feet, and you put in 50 feet or something like that, we can fix that, because that's an error. But
Yes.
But they say, oh, I need a new waiver for this thing we didn't anticipate, then it's say, new application time.
Not necessarily new application time, but there's a process under the regulations for a modification.
All right.
So the applicant would have to notify you, they need a new waiver of sorts.
Okay.
And the board would first have to determine, do you feel that this is what the regulations call a substantial versus an insubstantial modification? If you felt it was insubstantial, you could just approve it at a regular public meeting, no need for a hearing.
Okay.
If you feel that it's a substantial change, then you have to advertise a public hearing, notify abutters, and then in the context of the hearing, you'd vote whether or not you want to approve or disapprove that modification.
All right, that makes sense. Okay, so,
I have a question on number 1. In the last sentence, after submission and completion, the comprehensive permit approved by its decision shall be deemed to run with the land, which means it's deeded that way.
Correct.
Okay. We understand that then.
Yes.
so essentially, that would be a condition on the land that's at the registry of deeds, and anyone who purchased this property
Right.
thereafter is on notice of that these conditions are imposed. Now, do they record a copy of this at the registry of deeds, this decision, and the waivers? Is that,
Yes.
okay. All right, so,
I have a question. So the ZBA stays involved through this whole process? Like, we did the permit, and then any other issues that come up along the way comes before the ZBA?
It could be 20 years from now, as I've seen in other communities where something pops up and that implicates this decision, and the applicant would have to come back to this board, yes.
Would it have to be us three or whoever's
No.
on the
Well,
board?
No,
years.
whoever is
Well,
on the board at the
obviously,
time.
20 years. We might not be here in 20 years. Okay. Just curious.
Good
Okay.
question.
all right. And in number 4, the date that's going to be entered would be the date of the decision.
Correct.
Okay, and I see in number 5, you cite the regulations that require changes and how they go about.
Right.
Okay. Okay, so, anyway, so no building permits until they record the decision, no certificate of occupancy until they record the condo docs.
And we review all of the condo documents before anything gets recorded.
And by we, you mean the ZBA?
Well, if you'd like to review it, but typically we just have the documents come to town council.
Okay.
And we review for consistency.
Good with that.
Especially in this particular situation where we've got 2 layers of condominium associations.
Okay.
So that doesn't technically require a vote of approval from the board if we delegate that.
No, we'd review the documents just to make sure they're consistent with the decision. If we identify anything that is not consistent with your decision, we'd tell the applicant. The applicant would have to either make the documents consistent with the decision, or if there's a reason why the applicant can't, that could trigger a modification of the comprehensive permit itself.
All right. Okay. All right, so I think that covers administrative. Let's move on to housing and see if anyone has anything about housing. All right, so obviously number 13, this is not age restricted. Anyone could live in this unit who could afford to buy one. Let's see. And let's see. All right, and the next paragraph talks about the inventory, how many units, and how affordability is determined. It goes on. Okay, and it's essentially the intent of this paragraph, most of it is to ensure that affordable units remain affordable, and they are included on the town's SHI, which I assume means subsidized housing inventory, so that essentially counts to the credit for that magic 10% affordability number that all towns look to strive to obtain, no doubt. Okay, all right, so now if we go down to, if we talk about plans, okay, all right.
So if we may, at number 19, I know you can't see it on the screen, but the bold language that was suggested as prior to the issuance of any building permit, based on some suggestions received from JD Civil last night, they're actually proposing that we change that to read, prior to the start of any earth disturbance activities.
Yes,
These plans shall be
I saw
submitted.
that several times throughout the decision. Essentially, the idea is that, before work gets done, certain things need to happen, sort of a condition precedent to that work being authorized. And again, obviously they have to start with earth shift disturbing activities, such as what we call earth removal. But obviously, so
It could also be site preparation work, though, too. And I realize this site has had a lot of work done to it already, but,
Just for access.
it would encompass that as well.
All right, so I think that the change, I would endorse that change.
Yeah.
Suzanne?
You have to
That's
vote on the
okay.
change,
So,
or,
yes, all right, so unless anyone, all right, so I suggest that we adopt JDE's language, generally speaking, unless there's a specific issue with something that we come to. All right, so, again, if we find that it doesn't make sense somewhere else in the document, we can always revisit it. But right now, let's assume that, wherever it's at, he did it multiple times where it says, so we're going to assume that it's going to read prior to the start of any earth disturbance activities. There's one on the next page. So again, all right, so there's going to be an as-built, all right, so there's an approved plan, there's going to be an as-built plan, which shows what was actually built. No, let's see, and, okay. Why is building inspector highlighted?
To ask whether that's where you want the plans to go. Every town does this a little bit differently. So, the requirement would be that the project infrastructure for any of the project buildings shall be substantially completed as determined by the building inspector prior to the issuance of certificate of occupancy. I think this is actually highlighted here just to confirm whether we refer to the building inspector here or a building commissioner here.
Oh, okay, so I think the title is building inspector, but,
Okay. We can confirm that.
yeah, yes, I mean, but if it weren't the building, if it weren't the building inspector, would it be someone like JD Civil, or?
Sometimes a board will say we want, a building inspector, maybe hasn't been involved in the process or maybe does not have the staff and the resources to review a project like this. So sometimes it will also incorporate your peer reviewer, who will then work with your building inspector.
Well, our building inspector and our staff are pretty limited in Plympton. Now, if we were, to suggest, could we do building inspector and/or JD Civil, depending on what, depending on the magnitude or the scope of the
Sure.
project?
Yep.
Because, yeah, I mean, the building inspector is pretty much one part-time guy, and we have one person in the building department who also works as, who's also one of the zoning enforcement officers, the building admin. So essentially, for a project of this size of 60 units, they might just not have enough.
Exactly.
Okay. All right, let's see. All right, number 25 talks about the pre-construction conference, and there was a highlight about how many days this conference is supposed to happen prior to prior, and says, 14, the applicant, and the comment says the applicant's requested 10 days in two instances. All right. Okay, all right, so essentially, the 10 days or 14 days prior to prior to construction. They're supposed to have this conference with people who are invited to attend building, fire, highway, conservation, planning, school, health, and board's peer review consultant. Again, I don't see, I don't see much the way a difference between 10 or 14 days.
Would we say business days?
You could do that as well.
Say 12, right?
Like, or 10 business days?
10 business days, yeah. I mean, that's pretty much roughly equivalent.
Right.
All right, so we'll change it to 10 business days.
So then similarly, Mr. Chair, moving into paragraph 26, you'll see we highlighted the board's designee
Yeah.
as one of the boards to actually review the submissions of the construction mitigation management plan. Because again, typically, your building inspector may not have the resources and the time.
Yes, I definitely agree. I think that should be the peer review consultant.
Okay.
Mr. Driscoll's firm should be the one handling that sort of thing. Again, I see the addition of the Conservation Commission in the next section. That seems to be appropriate for stormwater. Erosion control, especially the latter. Okay, all right. And again, in Part D, the board's designee, we'll change that to peer review consultant, since they've been involved in assessing the innovative and alternative technologies for the septics.
Okay.
Now, going on to number 27, 26 seems to be pretty standard. 27, I think this comes the closest to addressing the concerns about the MIPA issues. That obviously, that if there is any proceedings or findings or decisions that need to come from that agency, that would be encompassed, I think, under 27. Okay. All right, so 28, all right, talks about, activities, earth removal associated with that, and obviously not just that, but also construction as well. All right, so we give the hours of Monday through Friday, 7 to 4, and Monday through Saturday through, okay, actually, I remember someone suggesting Saturday be limited from 7 to 12. I remember who.
I know there was a lot of discussion. The applicant has asked for Monday through Saturday, 7 to 4, but it's really up to the discretion of the board.
I think it's not uncommon for construction to be Monday through Saturday.
No,
I mean, I'm just thinking of what were you going to say?
No, I don't see any reason to prohibit Saturday. I do like the suggestion of 7 to noon, just to cut down on the amount of work that has to be borne by the brunt of the neighborhood, even though most of it is commercial. So anyway, I would suggest, Monday through Friday from 7 to 4, and Saturday from 7 to 12.
Sounds good.
One quick thing I noticed on my version, I have 2 paragraph 27s.
Yeah.
I noticed
The
that, too.
numbering with various people jumping in with red lines, it'll all be cleaned up, yes.
Yes, and besides, you're looking at through some office program, I'm probably looking at through another office program, and, the numbering is, once you get through, the numbering is going to get all wonky.
So we finalize.
Okay, right.
Okay, so Saturday, 7 to 12 is what you prefer,
Yeah.
okay?
Let's see, 34 talks about SWPPP. Have we previously defined that acronym in the decision?
Stormwater pollution prevention plan. I think she
Yeah.
did say that.
I think it is further up. but we can-
24,
Okay. That's-
24C.
Okay, that's fine.
I think it was, say, 24. 24, yeah.
There's no
Oh,
C.
no, you know what, this might have been changed.
Oh, it's
from the
26,
original.
oh, okay, it's 26C, okay. all right.
Yeah.
So it is there.
It is
that's
there.
fine.
It just, I think it switched the numbers from
Yeah.
the draft I had.
Yep.
But I did look for that myself.
Okay.
I was like, wait. So what about 30, what JDE recommended? You haven't commented on that.
Oh, it says earth, it's again, it's another earth disturbance activities.
Instead of prior to issuing the building permit.
That's-
So
yeah.
that would be between issuing the building permit and starting the work.
Yes, and I think that's consistent how we dealt with it in the few minutes ago, is that essentially, that no work until X, Y, and Z has been accomplished. Okay, all right. Okay, all right, so 35 looks to be pretty standard about erosion control measures. Now, when you talk about erosion control measures, where are, let's see, it looks like they are specifically, supposed to be put on the plans, what measures they're supposed to use. Is it, what if someone were, what if the peer review says that that's inadequate? Do they have to come back?
If it's not shown on the plans, now some of this is shown within like the limits of work.
Yeah.
Some of this is also coming from a request from the conservation agent.
Okay.
So they're supposed to outline exactly where the silt socks or whatever needs to be placed. Your peer reviewer is going to review those plans, the construction level plans, when they come in. If for some reason the peer reviewer says you're not showing it or you're not showing it where it's supposed to be, again, they would go back and forth
Okay.
to say the revised plans need to reflect that you're protecting, the 25 no-touch zone, et cetera.
Okay, all right. And if there is a dispute, then it's not, and they can't agree, then obviously it sounds like it'll have to come back to us for, insubstantial or substantial change or modification or
It
whatever
could
that
be,
process.
it could be,
Okay.
yes.
All right. Okay, all right, so. Okay. All right, so number 38, again, I think that should be changed to the peer reviewer from building department, where it's highlighted there. Okay.
Now, one thing I just want to bring your attention to in paragraph 38, and this is up to the board's discretion, this does allow some flexibility with respect to what we call minimal field changes. And then in the sub-paragraphs there, A through H, you see some of the things that would be considered insubstantial, meaning maybe it isn't quite as it was presented to the board in the final revised plans, but we're saying up front that a change, for example, a shift in the building footprint of no more than 2 feet
Okay.
would not be something that we would require the applicant to come back to the board for a modification, or, changes in light fixtures, things of that nature. This is entirely within the board's discretion of whether you want to allow minor field changes to be made at the level of, say, your peer reviewer, or whether you want every change to come back before the board for your consideration.
Well, I think, for changes of these, but I do have one question about it, but I'll get to that in a moment. For changes of this magnitude or lack thereof, I don't see any problem with designating JEE as the board's designee to review these minimal field changes. But one thing I was concerned about is that when you talk about the 2 feet in walkways, I would think, I know that we had substantial discussion in terms of the width of the road and, fire truck access and that. So if we, and I know that they have the berms on the side and all that stuff, but I would think that if that's, I think they said we have 24 feet, from, I'm doing this on memory, but if it now becomes, 22 feet,
Yeah, that's not how I read this, but we can clarify the language to make it tighter for you. I mean, you'll see that we use the language no more than a shift, meaning for some reason or other, we're not reducing.
Okay.
We're simply saying that we need to move it a little further to the east or a little more to left, whatever it may be, perhaps to accommodate some other sort of natural feature that we are dealing with.
Okay.
But I can certainly add in that this shall not in any way reduce the width of the roadway
Yes.
and the width of any driveways.
And also, I believe there was also spacing between the
The buildings?
Yeah, the buildings.
Okay.
Mr. Chairman, just
Yes.
a quick question. I don't want to intervene unless I'm permitted, but I think I have something that might clarify this issue.
Go ahead.
Okay. Remember, these are the concept plans. We're going to come up with final construction plans. Mr. McKenzie's telling me, like, the location of a septic system might change by more than 2 feet from what you're seeing today.
Or the structures as well.
But we're making sure it's a shift, not a reduction, in when the spacing is important. Yeah, I mean, when we've designated, a width between buildings or roadway, it still has to be 24 feet. And if the final construction plan show that had to shift for 2 feet for whatever reason. So that's what we want to make sure is in the decision, is shift okay, reduction not okay.
Could we have it on the final plans then? Because these are the concept plans, and we're going to come in with construction plans, and there'll be septic system location plans. And if we're doing a shift based off of that, they'll be far more accurate in terms of their location.
Who reviews those, the peer reviews?
Yes,
Yeah.
I think we
I have a
Field
question. Will you guys be doing individual building permit plot plans for each lot as you go with different housing models? Or will those all be on the construction plans?
Well, I'm not sure about the housing models, but every site, basically, there'll be a site plan for a grading and utility plan for every
Every lot?
lot
As you go?
as we go, that need to be permitted with the Board of Health and, of course, the building department.
Good. So should there be something in there that covers that?
Okay. We can work on that one then.
Okay.
I've done, subdivisions before where we get the overall plan approved, the roadways and placeholder houses, but then when you get to like an individual buyer for that lot, they may want a different model house, which has different walkways, driveway layout and stuff like that, which might affect septic locations.
But this is really no different. It's a subdivision, yeah.
So,
But I thought for this division, you would be building you'd be building the units and to a common specification, and then selling them as either as-built or, that's how you do it, right? You build the unit, and then you sell it, and, you build more units as you go.
No buyer input, in other words.
Yes. At least in terms of structure. I mean, obviously, if there's interior features that can be altered, that's between the buyer and the developer. But in terms of outer structure, what the plan is going to be submitted, that's what's actually going to be built.
Is that how you guys are gonna do it?
Well, I think, aren't we held to the architectural designs that have been submitted?
The architectural will comply, yeah.
Yeah, so I guess we're not talking about necessarily about architectural, we're talking about locations of
Okay.
single-family homes and septic systems and perhaps driveways. We already know that on some of these lots, we've committed to, per the fire department comments, increase the separation distance between, whether it is two duplexes on the same lot.
Yes.
So we already know they're, at a minimum, those lots are gonna change. So, but as Mr. Driscoll said, every lot is going to be permitted separately by the Board of Health. There'll be a review of the septic system design, the grading plan, the utilities. The building inspector will have to ultimately sign off after the Board of Health issues approval for the septic designs and the wells.
This will be individual plans per lot, not the construction grade plan that you're gonna do right before you start building the road, correct? Like the update of these plans? It's gonna be.
These plans are almost they're construction level.
They're pretty.
Yeah, pretty close, yeah. So we're talking about the individual lot designs. The road,
Road not-
road's not gonna move.
Road or the
No,
drainage or the.
no. I mean, if those, I think those changes would require coming back. It's a modification, but not, the individual lots at this point are, we always put labels on a plan, are for demonstrational purposes only, to show that they can be built, we can meet the Title V setbacks, the well setbacks to the septic systems, that kind of thing. So, but the exact locations of these buildings, I mean, the locations will change,
Okay.
but not dramatically.
So that does seem to be encompassed within the insubstantial changes, or minimal field changes, as it's called in this section, this paragraph 38. However, again, if there's a disagreement between the applicants and the peer reviewer, they can come back to us and we can resolve it. All right. So, okay. Let's see. There was another comment here. Could you scroll down because you might be covering yours. See, wait, it says, I thought it said something here about if necessary, but but I'm having trouble.
There is, so it's in paragraph 39.
Okay. Okay.
My draft had proposed the applicant install a stone scrubber, et cetera, and as the rest, as you see that paragraph, basically to keep the sediment and debris removal from the site to a minimum. Applicant proposed starting this paragraph with, if necessary, applicant shall install the stone scrubber pad and et cetera. My question with that is, who says when and if it's necessary?
Yeah.
So I just think it warrants a little further discussion. I know some projects I've done, there might be a stone scrubber that's installed. Sometimes there's a rumble strip, but not both. Does the board have a particular practice here, or maybe there's a compromise?
Obviously, I don't think the board has any kind of practice with this. But what's the difference between a stone scrubber and a rumble strip?
I'm going to defer to the engineers present for that. I mean, I know both are designed to create some sort of vibration under the heavy truck's tires to get the excess soil off so that it isn't being traipsed out through the streets of Plympton and Carver. I think they both accomplish roughly the same goal. I don't know that one is better than the other necessarily. Perhaps Craig has a recommendation on that?
Show on the plans a stabilized construction entrance exit, and there's a detail on the plan as well. That's typical stone, like 2-inch, 3-inch stone. that I've.
It's almost automatic under construction.
Yeah,
It'll be in the SWIP as well.
please respect those as well. Pretty standard.
So then we don't need to include the language if necessary, because it's already
Yeah, it's already.
basically being shown on the plan. Okay, so that one is resolved.
We even have construction details for it, right?
Yeah.
Well, we certainly encourage anything that will help reduce the dirt coming from the site and the trucks that are.
There should be notes in the detail about maintaining it, and just taking the stone out, refreshing it. That's,
Okay.
you know, it's gold.
Keeping it clean.
All right, so now we're,
And that's something that'll be inspected during the SWIP inspections.
so now infrastructure, utility management. Okay, all right, so essentially, this is, all right, this is a private, essentially, this says this is a private road, and the unit owner is responsible for road maintenance, snow plowing, lighting, maintenance of sidewalks, and the subsurface filtration system, and we'll talk more about those. The decision does later on, all right. Okay, there was a comment here that says, JD suggests prior to commencement of construction activities, okay, all right, so
Same
that's,
as the other
all right, that's in 43, all right, so I think we can incorporate that, again, if that's consistent with our practice. So they have to do the stormwater management. Okay, all right. Okay, there's, all right, so the next paragraph, 43A, talks about the stormwater operation and the management system. It says the HOA is responsible for maintaining that. If they don't, the town can enter the property and fix it for them and charge the association with the cost. And essentially that, I haven't looked at I may have looked at the statute cited, but I think essentially it sounds like they become a lien upon the land.
Right, and again, everything that's highlighted in this paragraph 43A is totally optional. Just borrowing from some other decisions where maybe in another town, maybe they were burned by a particular project where a homeowners association did not maintain all of their infrastructure, and in some cases, it then has an impact on town infrastructure. And rather than fighting over whose responsibility it is, it would lay out the ability of the town to be able to go in. In this situation, this is really going to be an entirely isolated system, if you will.
Yeah.
It isn't connected to a town-operated system elsewhere to necessarily have those same risks for failure to maintain. Failure to maintain is really going to have an impact on the residents of this development, but maybe not the same level of impact on, the town's systems.
So if the town had a public water supply, for example, would this paragraph be more important?
I don't think it is so much the public water supply as much as when you see developments that they provide their own stormwater management and drainage, but then they ultimately release or discharge to a town drainage system, perhaps like out in the roadway or whatever. And if what happens here is going to cause flooding or a backup on a town road further off-site, then you could see where this might be important to the town.
For the geography of this location, there aren't any town of Plympton roads likely to be affected, because you have Route 44, which butts their property to the north. You have, I think it's Spring Street, which is technically the town of Carver, but that's also, some fairly distance away. So it'd have to be a fairly substantial flooding before we consider flooding the public road. Obviously,
If I may, it also could flood the residential areas in the housing and utilities and cause problems within the development or
Yes, it could.
project.
I mean,
Then it's more up to the HOA or COA to come forth and provide maybe resolution, or is it up to the town to jump in and suddenly be burdened with that?
Yes,
At a huge
and,
cost?
you know, and
I don't get it.
No, I see where you're coming from, because, obviously, the HOA, they're the ones principally responsible. Now, this
I would
gives the
think so.
town an option, and I read it as an option, not a duty, to go in if the HOA is not doing its job, to essentially do it for them and bill them for it, so.
Certainly, if there was a public safety or health
Yeah.
threat, we would have to, as
Yeah.
public servants, fire and police and even
why not?
DPW. Now the burden is on us.
And so by including
How are we
that-
going to get compensated?
Oh, that would be the lien language.
Right.
That's
Yeah.
that's included at the end of the section.
And that is where?
The very
The
last
last sentence.
sentence.
Oh. Town in connection with this requirement, property shall be reimbursed by
The cost.
30 days of the town's invoice to whom?
To the association.
Okay.
I mean, that's what it should say.
Oh, well, it should say
It needs to be
someone
added
gets
to
this
documents, too,
bill,
then.
you know?
Right. As I said, you don't have to do this at all.
But I don't see why not.
Well, I think it's a good
It's
protection. feature.
entirely,
Yes, I think we should adopt this, because, again, it's optional, but it does give the town remedies, in the unlikely events that the association cannot fulfill its duty. Again, I think that the general philosophy of this town is generally live and let live as much as possible, but still, when considering a development of this size and density, there may need to be an instance, unlikely, and with good management, probably never going to happen, but there may be an instance where the town needs to step in to protect the people. An extraordinary event, we should have the explicit right to do so, not the duty, the right, and of course, obviously, to seek reimbursement for costs imposed. So I think that on that understanding, if we need to tweak the language a little, we should definitely incorporate that to this decision.
will do.
And they didn't have any issue with it, right?
No.
No? There we go.
Okay. all right.
It was in 42 before this, not to go backwards, we shouldn't do this, but it says the project's overreaching HOA and individual owners. Is that the individual homeowners associations?
Yeah.
Or what's the overreaching one? That's the
So there's
condo
the-
association.
Well, there's the overarching homeowners association.
Right.
Because the roadway, the drainage, stormwater, all of that
The
is
common
in
owners.
common,
Yeah, common
if you will,
owners, right.
right? So that's the overarching homeowners association. Then each of these lots, whether it's one duplex or two duplexes, are going to have their own individual homeowners association
Right.
over, who plows their driveway and who mows their grass, that kind of
Right.
thing.
But there's no burden on the town with the individual homeowners association, or that would,
No, we're not going onto anybody's private property
Right.
and,
they just have an
fixing their
agreement
septic system,
among
for example, no.
themselves.
But you do raise a good point that in 42, we should say individual homeowner associations.
Okay, right.
Okay, yes.
That
No, no,
is it condo association or is it homeowners association? We've got to make that distinction.
Condo.
Because I can't get it through my thick skull, which, because I've never been a member of either and don't want to be, but anyway, especially in this one.
Each lot will be its own condominium association.
Each lot is a COA, okay.
Okay.
And then there's the HOA for everything else.
Well, so you'd probably change it to individual
All right, that's all I can say.
associations.
Condo
Yeah,
associations,
As
yeah.
opposed to unit owners. Okay,
Right.
That makes sense.
Okay, are we free to go on to number 44?
Yeah.
All right. Now, number 44, we spent a great deal of time talking about the nitrogen load on the various units and their septic systems. The lots and septic systems. So, this one I think is, especially important that we review this one thoroughly, because, many questions were raised, and it'll come up again. It should come up again. It'll come later on in the document, but Anyway, all right, so they have to, identify this, prior to the issuance of disposal works construction permit, do we grant such a thing?
That was the change in language requested by JDE.
Okay,
And that's the permit that they get from the Board of Health to build the septic system.
all right.
Oh. Can we say that?
Want to add in by the board?
I mean, we could say,
Yes,
prior to the issuance of
BOH.
a septic system by the, a permit from the Board of Health, we could do that if that's less confusing.
But it's implied by the, as long as we know, right?
Okay, all right. Okay, all right, so the cost is borne by the applicant and the homeowners association for these technologies. The overarching HOA will be responsible for unit owners, maintain a working generator. Okay, all right.
It's only one permit, right? Or is this a different permit? I just want to make sure. 'Cause we're
I think they're going to get
Another
30
permit from-
permits,
okay.
like one for each lot.
Okay, and that goes through the health department?
Right.
Okay. Which is helpful. So it's not like that one, so even if we say, yes, okay, move forward, we're just approving them, but they still have to go and get more individual permits. That won't come before us, will go before the
Right.
Board of Health.
The permit has to be consistent with what you've
What we've
decided.
said,
So it's
okay.
got to allow, if you ultimately approve this, and you're granting a waiver from the Innovative Alternative Technologies prohibition, the Board of Health has to honor your decision.
I see, okay.
All right, so now,
But they still have to look at it and approve it and
Right.
everything. Okay.
For the state purposes.
Yeah, okay.
all right, so now in terms of oversight, it says the HOA will handle, essentially, that's responsibility of the overarching HOA to ensure that each individual unit, associated unit owners, maintains their system. They have the generator. The generator has to be on at all time, or available at all times. Let's see, maintain such generators, watts. Okay, all right, so now number 44 does not give the town any particular authority, unlike number 43, to enforce if the HOA does not do its job. Is there any, and this may be any, a question, this may just be a no, but can we not incorporate a paragraph similar to 43 into 44 that says if the homeowners association is not enforcing it and it looks like the units are not, the unit's not operational, then the town can come in and make sure that happens?
You could, now, first of all, if it's an enforcement issue under the permit, we can enforce our comprehensive permit. So we can notify the homeowners association that they have not been providing, whether it's annual reports or whatever they're required to provide, to show that these technologies are being maintained in accordance with the manufacturer's recommendations. We as the ZBA could say, you've got 30 days to get all of these notices into the Board of Health if we so choose.
Okay.
You could also put some parameters in there like you were just discussing, but I don't think we necessarily want to do quite what we put into paragraph 43. I don't know that you're suggesting that if the HOA fails to maintain all these septic systems, that the board is then going to have the authority to go in and...
Yeah, yes, I was sort of thinking aloud, because essentially that kind of sounds a little unwieldy. I mean, how are we going to do that with individual units? For example, theoretically, right, and I'm not saying this is going to, I'm just really thinking aloud here, we could have random inspections, that the ZBA, that the zoning officer comes out on random dates and inspects to make sure that the thing is, that the generators, the thing is working, however you do that. or something along those lines. But again, I understand how it gets a little further than a stormwater oversight, because now you're talking not just about the whole, but the individual that may not be in compliance, whereas, the other one unit might not be in compliance, but the other 59 are fine, or however many there are, 30, I think it is. So anyway, so I'm not sure if we can do that within our permit. I mean, I can understand, if someone says, hey, the unit's not on, it's not working, and we say, hey, fix this, or fix this, come back with compliance, or else deadline date goes by and we start looking at fines. Now, as I understand it, those fines can become liens upon the individual units, I think.
The other thing to bear in mind is that each septic system is going to have a Title V permit issued by the Board of Health. So the Board of Health also has some teeth in this in terms of being able to enforce the septic permit.
Can we ask that question to the Board of Health, or is that not allowed as a Board of Health member, Jared Anderson?
We got two.
If you don't mind, if not, we
Yeah,
can...
sure. I'd be happy to comment if you want.
Well, if that's okay with Mr. Chairman.
Yeah, sure.
Okay. Yeah, you're good.
So I think what we discussed last time when we were considering conditions were that there be a power supply that wasn't accessible to the homeowner, or if in lieu of that, maybe some sort of warning system that makes it known to us or some overseeing body that it's been disconnected. But I think the main mechanism, and Arthur, you can correct me if I'm off, but was going to be like a sampling program, maybe like a quarterly sampling, and that would pop a red flag that would show us that, this system isn't working the way it's intended. And then so basically, we're not going to be going around policing people's house. I think the bulk of the of the way we would administer it would be just administratively. If the system was no longer compliant, which would be proved by water testing, then we'd go into sending a letter or some sort of order to correct.
I think a good point that Jared made with the inspections would be done on a regular basis, and we report back to the Board of Health with each of these inspections. How the inspections would make sure that the generators are functioning as expected.
Does that
I think that was...
kind of answer your question?
Yes, I think that is helpful. I like their suggestion about the cyclical inspections, and I think it should be, I would like something in 44 that just something about that, and also to note that the inspection should be randomized. If you're doing it the first day of every quarter, then it doesn't work. I mean, so I think that that public should be put on notice. People are going to be buying these units, that they're going to have to handle, random inspections that may have to enter onto their property for that limited purpose. So with that, I think we should make sure that that's somehow in there to give people notice that they do have obligations that may be unusual, but in these circumstances, the board, I think, may feel that are valid to try to address the concerns, and also to make sure that the alternative technologies are really being utilized as they're required to, because of the nitrogen load that these lots are expected to bear. Yes, Tony.
So it would be like, all of a sudden, someone shows up, no notice?
I mean, that is kind of the randomness of the...
What happens if they're at work?
There are O&M, there's an O&M plan, and there are inspection and reporting requirements for these systems by law, by Title V. So I don't know random testing is, who's going to do the testing? Who's paying for the testing?
Good question.
That's a good question.
It is.
Town doesn't want to
But
pay for the
if they're
testing.
mandated or outlined in some operation and owner's manual, then it should be presented to Board of Health when they finally
It has
apply
to
for
be
these.
By law, by Title V. It's
Right,
required.
per Title V.
Yeah.
Yes, Mr. Bloomquist?
Yes, sir. The O&M is exactly what we're talking about. This is not an additional process. And the O&M is also paid for by the owner. In this case here, I believe the HOA is paying for
Okay.
it. But
Okay.
there's not another layer, it's the same thing.
Okay.
All right, so then perhaps we can sort of, perhaps it would just be best to say that, will be governed, inspections, maintenance, reporting shall be governed by Board of Health rules and regulations.
An O&M approved by the Board of Health?
Yeah, I'd be good with that.
I wouldn't say Board of Health regulations. Don't forget, we have to ask for a waiver just to implement these systems.
Yeah.
So maybe just an O&M approved by the Board of Health for inspections and maintenance.
That would work.
Something
Yeah,
like
that would work.
That's good.
We're good with that.
Just so it's articulated.
Yeah. I think that covers the issue with the, I think 44 is the only one that mainly addresses the nitrogen loading.
It comes up again in the waivers.
Okay, all right, so we need to revisit that later. Okay, number 45, no garbage disposals or grinders. Let's see, 46, there's a blank spot in 46.
Right, so this was something that, again, JDE flagged. There is a waiver with respect to some coverage that is going to be allowed over pipes, but JDE did suggest that we at least specify the minimum depth of cover. And I don't know if that's something that the applicant has available at the
It's in
moment.
It's actually in the waiver list.
Yeah, they can do it.
We specified,
The minimum, so we don't really need to say it again here.
probably not.
12 inches of cover up to 36 inch pipe or something. ADS.
Well, we
Might
actually,
even be more.
per the plan, we actually identified what that cover is with the,
So it'd be a duplication, okay.
yeah.
All right,
Yeah.
So, so we just cross the decision, but it's like, see waiver list for more details, or words to that effect.
Yep.
Okay. All right, number 47, it says 4 bedrooms, 4 or 8 bedrooms. Okay, okay, that's, all right, so that's the 2-unit duplexes. All right, so.
Right.
All right, so,
Or the lots with more than one duplex.
okay, all right, so the math makes sense today, it doesn't make sense.
Yes, yep.
Okay, next section talks about fire department conditions. Okay, it looks like it's 25,000 gallon cisterns, what was requested, not 30, okay. Okay. All right, all right, no on-street parking on the main road, so that, so we pretty much went through most of this by the end of the last hearing. Okay, all right. Obviously, J, I think, the lots need to be, correct as to which lots, for the fire access. Let's see. The document I says is lots 9, 10, 11, 12, 17, 18, and 19. I don't have the plan in front of me, but I assume those numbers will be correct when we have the final.
Right, and I know that Mr. McKenzie had requested a change to paragraph M, and the lot numbers are slightly different. I just want to make sure that as between J and M, we have identified the correct lots based on the most recent revised plans that were submitted.
Okay. So let me ask, between J and M, why is Lot 9 on J and not on M?
I think they should be the same.
And that's what I wanted to confirm. Should be so it should be the same as M?
Whatever's in the fire department letter, that's why I asked for it earlier, I think.
I don't think their letter identified the lots, though, for the standpipe.
It said affected lots, which
Right.
implies to me that they're talking about, earlier in the letter, 9, 10, 11, 12, 18, and 19. They actually don't mention 17. But I think perhaps you added 17 because it still has a common driveway.
Exactly.
So should we also clarify about the driveway width, that the common portion of the driveway needs to be 20 feet? That might make
That's
sense,
what we
because
decided,
there's
yeah.
no need to have 20-foot individual driveways from the common driveway. There's no need for that to be 20 feet wide all the
Right.
way.
So the common driveways servicing those lots.
Right.
If the applicant could just double-check the lot numbers before we finalize this to make sure.
Well, I'm referring to the fire department, because they had a concern about 9, 10, 11,
Yep.
12, 18, and 19, wanting them sprinkled, and then we agreed, they gave us an alternative in the letter, and that was to install the 4-inch
standpipe,
system
right,
within
which-
50 feet of each affected property, which, again, refers to those, I believe refers to the lots.
The same
Have a
lots.
concern.
Same ones, yeah.
Yeah.
Okay.
But they didn't mention, I don't think they mentioned, again, I don't think they mentioned 17. They didn't mention 17, for some reason.
Are you saying that 17 should be included here or excluded? Because like I said, the fire department didn't actually identify the lots by number.
They did.
I think they said the affected lots.
On the 5/28/20, no, at the beginning of the letter, they mentioned a concern about these 6 lots. So they.
Okay, the letter says specifically the Plympton Fire Department recommends the installation of residential sprinkler systems in units located on lots 9, 10, 11, 12, 18, and 19.
So not
And then they gave
17.
the alternative.
The alternative, say, the affected lots, so that, to me, implies that they're talking about these 6 lots as an alternative to sprinkling them, to put in the standpipe within 50 feet of each of the lots. I think that's what we discussed.
And does lot 17 not have a shared driveway like
It does.
that with the?
It does, but they didn't mention it for some reason.
The fire department letter may not mention it, but we then had a discussion here about any of those that were
This one
sort of like
here.
stacked behind each
I
other.
Yeah, this one
think
here
we're
is
okay with adding 17.
Yeah.
It's right next to 18. and
Yeah, so
we're
these
gonna
Right.
type up to
conditions are
anyway,
identical.
So we don't need to make any change
Well, you
to the
add
lots.
9
I
to
think
the
the
M.
paragraph should be the similar, J and whatever.
That's 18.
Yeah, so J.
So we'll just add lots 9, 10, 11, 12, 17, 18, 19.
Yeah, that should also
So
be
add
in
9
M.
on M.
Yes, okay.
Yeah, because I can't see any reason why I should exclude Lot 18 and Lot 17 and include Lot 18. They're just so similar. That's-
Right.
I mean, and that could have just been, an oversight on the chief's part. Okay,
Okay.
so,
Should the 9 be included here?
yeah, 9's going to be included.
Yeah, I think they went over that, so they're identical. 9, 10, 11, 12, 17, 18, 19. Stormwater.
All right, stormwater, all right. Okay, let's, all right. Okay, I think the change to number 50, it says, shall show the snow areas on the construction level plans. I don't see any issue with that. That makes sense. Although there's a comment here, okay, so so number 51, the JDE suggested it's going to read prior to the issuance, prior to commencement earth disturbance removal activities, okay? I think that's consistent with what we've previously done in other sections. Okay.
Do we need signage for that? I suppose that comes later.
Well, no, I think all this looks, pretty standard for, and I see no issue in it. Okay. Now, when you get to 52, there's a paragraph similar to what we looked at in was it 42? Yeah, I think it's 42 and 52. Have a very similar paragraph suggestion included. Let's see. Is it necessary to have that there in both?
No, we don't need to have it twice, no.
Okay. Although, there is this last sentence here, which seems to be unique to 52. It says, prior to the issuance of occupancy permit, Garbage shall grant to town an easement for purpose of accessing and making emergency repairs to stormwater consistent with the paragraph. That's an interesting idea.
Put that in the other paragraph.
Yes, we could put that in the other. Why don't we cut that and put in number 42?
Add to 42.
All right, now, is that, the easement, is that a temporary or permanent?
It would have to be permanent because it could be invoked at any time. The purpose would be that we have the right to enter and maintain the stormwater system in the event the HOA fails.
Okay, all right, so make sure the word permanent is there, please. I don't see anything else here of note, other than, again, there's another instance of prior to the issuance, and again, earth disturbance activities. I think that's pretty standard by now. Let's see, so we go down to site improvement and management. Okay, all right, okay, all right. Now number 56. I like the changes, but I do have one concern about that. For example, it says snow shall be transported off the site within 24 to 40 hours then the storm event. Now, what happens if we had another 100-year storm like we had this winter, and that might not be possible just because of everyone's still digging out in 48 hours. Can we not have a little bit more leniency in the event of an extraordinary situation?
Well, again, if you have an event like we had in February where everyone is shut down for a week, I don't think anyone is going to be concerned with looking up the conditions of this comprehensive permit to see whether or not we can, issue an enforcement order. It's always within the discretion of the town whether or not to enforce a term of their permits. So if you want to build a little bit more flexibility into the 24 to 48 hours, you can do so. If we have an extraordinary event that occurs again, you simply have the discretion not to enforce.
Perhaps at the end of the sentence, we could say something like, within 24 to 48 hours, the end of the storm event, absent extraordinary conditions, or something like that.
Sure.
Well, it's also 24 to 48 hours at the end of the storm event. So if the storm goes on for 5 days, then you still... So, anyway, that's what I was thinking. Because the end of the storm event...
I mean, it depends on what, if you consider that when the snow stops falling or when the roads are clear. If the snow stops falling, then it's unreasonable, but if the roads are
Yeah.
clear, then it makes a little more sense. Although, again, Plympton, our town was well praised this winter for our road clearing activities. However, other towns were not so, were not so praised.
You did good.
But anyway, but I would like just
Power to.
a few words in there about, indicating these people that, we're not going to be martinets if the next 100-year storm comes next year, or the year this place is built.
Okay.
Okay, so now down to hydrogeology.
Now, this one on 59A, this might be holdover language from an earlier GEI report, because the applicant flagged that GEI did not recommend this in their final report. I only had this brought to my attention at about 10:15 this morning, so I haven't had a chance to dig back through the GEI reports to bring that forward to see if that is correct. I don't know whether JDE has had a chance to look at that, and do we agree or disagree? I think that just one we have to confirm, go back through the reports and confirm.
All right. I think I remember there was discussion. I don't remember what the result was, but I think that would be prudent to include that unless it appears to be clearly unnecessary. Obviously the surface water, does have, people have raised concerns about potential impacts to the surface water, so unless that's ill-advised, I would like to have that in the decision.
Why would they not want to do it?
Well, I'm not sure that I'm the best person to speak on their behalf, but I think potentially two reasons. One is their Ricketts Pond is not on their property, number one. Number two, this just says that they should collect water samples to rule out a potential source of contamination. So let's assume the water samples come back and there are some traces of whatever contaminants that are detected. Doesn't necessarily impose any kind of a duty on anyone to do anything with that. Doesn't necessarily say what the source of contamination might be. It's just gathering information, but then what has to be done with it.
What would normally be done? I mean, have you been in circumstances similar to this?
Normally,
Like-
there's a situation where a property owner who has engaged in some sort of activity, or there's been some sort of release on the property, there are certain thresholds that require, reportable releases of whatever it may be, whether it's, some sort of contaminant or
That typically falls under 21E.
under 21E, and then, strict liability to the property owner.
Yes. I mean, obviously, and as you say, Ricketts Pond is not on their property, but the body of water is close to it, and undoubted, and I'm not sure. You wouldn't be surprised to me if that it does have some sort of hydrogeological impact on the groundwater that this property is going to have to draw from as the residents use it. So I think it seems to be prudent to include it unless, again, the report is clearly contrary.
If I may, it could affect just health and safety of occupants if they're walking, bringing animals down, the kids playing in it. You'd like to know if it's polluted or not. So,
And even just for notification to whoever's.
Yeah, just so that it's tested.
If I recall, and again, maybe Greg can jump in,
Yeah.
this came up in the context of how is water flowing underground for
Right.
purposes of impacting
The drinking
what
water.
will ultimately be the wells for drinking water
Right.
for these duplexes?
Mhm.
And that Ricketts Pond was not part of the area, that there wasn't any data about anything relative to Ricketts Pond that could impact any of these wells. But when we get to the waivers, there are requirements in there for testing to be done before, well permits will be issued.
For Ricketts Pond?
No,
Not for Ricketts Pond, but for the
wells
individual
themselves.
lots.
Right, but what if the surface water is indeed contaminated by some means? Would it behoove the public to know that it is contaminated for signage and protection and awareness and all that good stuff?
Another issue is that's private property, that's not the applicant's property, they don't have control of it.
Well,
Enter in samples.
It's not public land.
then it's HOA's responsibility. Let's put it on them again.
But it's not even the
But it's not 'cause
HOA's, it's not
on
their
their
property.
We wouldn't have any ability to comply with this.
Oh, it is not on the property?
No.
But it's within walking distance?
We still can't, we can't go on somebody else's land without trespassing.
Yeah.
And they can't come on your land?
No
without-
access from Ricketts Pond Drive to the pond.
Okay.
So,
Then I'm not picturing the whole layout.
and we don't,
Okay.
the applicant does not own the pond, so even in Carver, and so he would have no control over if it's polluted, they would have
Okay.
no control over that. And it doesn't necessarily mean if there's some form of pollution that it's going to impact. The hydrogeologists have not concluded that, that there'd be an impact through the aquifer to the wells. So I think that's why
There's
GNR is
Ricketts
okay in
Pond, that's
striking
their
that.
site.
This is
The
the
last
pond, this is
letter.
the industrial
Yeah.
park, so it's adjacent, but it's not on the property.
Is it possible that work they've done up to this point could have affected Ricketts Pond? Or no? Because I know there
Well,
was a
that's-
lot of...
That's Carver, too.
Mm,
So it's entirely in Carver?
Yeah.
okay.
All right, that's my mistake, I'm sorry. I assumed it was close, or at least, part of it was inside
Now,
that project.
There is no fencing around Ricketts Pond that would prohibit individual access to it, is there?
No, but we would, without permission of the property owners, we'd be trespassing.
Yeah.
Yeah, it's not there.
As would any member of the public who's walking their dog
Right.
down by the pond.
Mhm.
So should there be signage? But there was that up to Carver.
Whether there should be or
Yeah.
shouldn't be signage, it isn't really for this
For
board
us.
to say.
Okay.
So,
Yeah.
anyway, now,
So we could
as I
eliminate
as
that.
I understand it, the pond itself, being designated as a pond, I think that is public, but the land surrounding it is private. Is that the idea?
If it's greater than 10 acres, it could be a great pond.
Yeah, I think I remember someone saying something along those lines, but I can't remember, so don't quote me. But anyway,
So would we just eliminate that, or you want to?
That's what the applicant is saying, that GEI ultimately landed on eliminating that condition.
no.
Oh,
All right, well, I think under the circumstances, I think, if that, if after a double check that is the case, then, yes, we should eliminate that. Again, it is, someone else's,
yes, no liability.
Yeah, it's meant, yes.
and it's not, I wouldn't exactly say it's closed, but it's not abutting, there's wooded area, and obviously people, obviously, no trespassing signs only go so far to where people want to walk their dogs, but anyway,
Yeah.
but it does appear that the land, Google Maps is very difficult to see. It shows land boundaries, but it's very difficult to see them because they're
Oh,
like,
you have to click a theme or something.
yeah, I think I have to put, you can kind of see the squiggles over
Yeah.
them. But it's not, but the contrast is very bad. But anyway, that's all right,
Yeah,
so,
you could just eliminate it, call it a liability for
yes.
the future,
Okay, all right, so,
or at the first instance.
all right, so parking, circulation, and traffic, I think,
The bridge will definitely be better.
okay, all right, so 61, there's a blank space and the number of ADA compliant parking spaces.
I don't know if Mr. McKenzie can answer this. Are any of the on-street parking spaces, are any of them designated to be ADA compliant? None.
Not currently, and I'm not sure it's
That they're
by
required at
law.
all, right?
It's not a parking lot.
Right.
You know, like a for a commercial or just like,
Right,
for ownership units, they're not,
Right.
handicap parking is not required.
right.
And as I see on the plan, it doesn't really make much sense because,
There's no accessible route.
yeah,
I mean, to a particular unit, somebody would,
I was
I
wondering.
mean, if somebody has a handicapped a resident or a guest, they're gonna retrofit their unit. If they're a resident, they're buying a unit, they're gonna retrofit their unit, they're gonna park in their driveway,
yeah.
so.
And I believe, but speaking along those lines, I believe there's somewhere in this, does there need to be something about no ADUs built on this, in this
I
project?
thought we did include that somewhere, but I
Should be, yeah.
make sure.
I'm not sure you can do that.
The HOA can prohibit it.
Yeah.
Okay. All right, let's see. Number 80, it says, no,
Is there an objection from
I don't think so.
HOA person? Okay.
No. You don't want ADUs on these things, do you?
no.
Well, not to mention,
The septic.
your septic system may not be able
Yeah,
to
I don't think they
accommodate anything
qualify.
larger, so.
All right, so,
Lots would have to be larger.
all right, so anyway, we sort of jumped ahead there, but,
Yep.
you know. But that's the beauty of this process, you know, we can jump ahead and back if we need to.
Yeah.
I have a question too,
scroll.
though, that, I thought there was a single car garage per unit. Is it just per duplex?
Per unit.
Okay, because it just said 61 at the top. One driveway parking space plus one single car garage for each duplex.
That should be unit.
For each unit,
Good catch.
okay.
Good catch, yes.
Each unit. Instead of duplex. No, I know what I'm saying.
Okay, all right.
Jump down.
Okay, I think, are we, like, on, oh, so, anyway, so we're getting rid of the ADA compliant?
Right.
Okay. All right, so I think we're roughly around 63.
ADA compliant.
Yeah, we're getting rid of that.
Yeah, getting, oh, I see, okay. 63, 62, vehicle.
Okay, all right. All right, number 63, it says applicant shall maintain or replace the fence along the rear property line abutting the Mass DOT basin. That was a change in word from, I can't see what.
It was from the edge of the traveled way, and JD suggested that should be from the edge of the right-of-way.
Oh, but this change refers to, no, I'm talking about.
Oh, you're up above on the
Number 63.
No,
basin?
not quite.
The basin, so this was a condition to require the applicant to maintain or replace the fence around the basin, and it was just, again, for the board's consideration.
Okay, I think that's a reasonable condition, but should we also include there that the HOA's obligation to maintain that should follow?
That the HOA
Maintain it.
maintain the fence?
Yeah, and then, yeah,
Okay.
after the applicant does, then the HOA is responsible for maintaining that fence.
Okay.
Okay, now 64 on the screen, it says the decision shall serve as street operating permit. Now, that doesn't make the street a public street?
No.
Okay.
Nope.
Because we've made it clear in the decision, this is going to be a private road.
Correct.
Okay. Okay, all right. All right, so 65, there was a change suggested from traveled way to right-of-way. I don't see any issue with the verbiage.
23 feet, yeah. Measures.
I think that's fine. Okay. There's something in number 7D, if you scroll.
7?
Number
70.
70, yep.
Oh, 70, yeah.
I think the original requirement for stop signs and a crosswalk was something that came up in one of the traffic reports. And the applicant has noted here that there's no sidewalk on the opposite side of Spring Street, so why would we put a crosswalk to nowhere, especially where there is no, like, handicap ramp on the other side?
Yeah.
So perhaps this is something we just strike entirely?
Okay, all right, but before we do that, the stop sign, the idea of a stop sign is not something I'm opposed to, the crosswalk thing is, I agree. But anyway, if there's going to be a stop sign, is there going to be a stop sign at where the property ends and goes on to the to the industrial park part of the road, or is it going to be actually where the industrial park ends and Spring Street begins?
This was written at the intersection, the approach to Spring Street.
Okay.
So it could be that it be where the Ricketts Pond Road, say, entrance to this development meets the Ricketts Pond Road industrial park portion.
Okay.
So
Inside
I
the
think
park.
there is I could be wrong, I think there is a stop sign
At Spring
at Ricketts
Street?
Pond Road and Spring Street. I think there is.
Okay.
And should there be a crosswalk there, though? Is that what they're talking about with a crosswalk?
There was a recommendation in one of the prior traffic peer review reports, but again, the comment being that if you don't have a connecting sidewalk,
Yeah, it doesn't make any sense.
why would you have?
Well, you do on the, if you're going north on Spring Street, Carver, and you cross the entrance to the industrial park, there should be a crosswalk there, because the sidewalk's on either side, I believe.
No, there's, here's where Ricketts Pond, the driveway begins from Spring Street, and there's, as you say, there's a sidewalk on this side, but
Right.
but on the other side.
No, this side, on the same side of the road, there's a continued
yeah,
sidewalk.
yeah,
Should there be a crosswalk here?
I don't think so. I think that's,
Well, why not? I mean, there's industrial traffic as well as, the 60-unit traffic. And maybe you're not understanding where this crosswalk should be.
You're not going across Spring Street, in other words,
No.
you're going parallel with Spring
Parallel
Street.
with the yellow lines on the residential side.
yeah. Okay, I see what David is getting at. So you
So
have
across
the
the-
sidewalk, and then you have the exit to Ricketts Pond Drive, and you have more
Right.
sidewalk that goes up to
Well,
the
there's a
highway.
sidewalk with ADA, I think, at this end, but there is no ADA here. It's just a berm of tar, if you will.
Okay.
So you could improve it, you could put a marked sidewalk, a marked walkway for the pedestrians, cyclists, and for handicap to get over toward 44 if they want to go back on Spring Street into Plympton, or the industrial park, or...
But on that point, on Ricketts Pond, essentially we're asking them to paint lines on Ricketts Pond, on Ricketts Pond
A
Drive.
crosswalk, whatever the town would require. Although this is not
This is
Yeah,
Plimpton.
that's
Carver,
what-
that
So we
would,
can't put paint on on Carver streets?
Right.
Oh, if it comes down to that, then we lose hands down, because Carver's never been here to vouch for anything, so...
But for this part here, right?
Right.
See how this...
Oh, it's walkable,
Yeah.
but
But
it's...
is this part here, is this Carver property, or is this Ricketts,
Well, Ricketts Pond is all in Carver, their business park.
yeah, I know.
So it...
But this little strip here, right, where my finger's going down, is that
Right.
actual town of Carver land, or is that actually Ricketts Pond, industrial park? old
Ricketts
land?
Pond Road is all in Carver, correct?
Yeah.
Correct.
Yeah. So that portion of the sidewalk going north up toward 44 would also be in Carver.
Yeah.
To someplace out in here somewhere in the woods. The
Yeah.
land probably ends right there.
Yeah. I mean, you can go all the way down here, and you'll eventually get to the cul-de-sac, and then get to the,
To 44.
from here, you're getting to the development area.
Yes, the
44
development, I meant this
44 is
way.
here, yeah.
Yeah, there's 44. In fact, you could probably see the overpass right there.
Yeah. I mean,
That's up to the
The crosswalk is within.
people that battle here. I'm just suggesting it.
Yes. I mean, one thing I think might, I do like the idea of having a stop sign here.
If there isn't one already.
I don't see it. I mean,
This isn't another town.
Yeah. I mean,
I know, it's
No,
kind
they,
of,
yeah, they realize it's
But it's
Carver,
also
yeah.
within the Spring Street right away. The town of Carver would need to be involved in this.
yeah.
Right.
right. Yeah, you can't tell the highway department
Yeah.
what to do.
Yeah.
Yeah.
So should that be eliminated then?
I don't see,
We need wheelchair ramps, we need.
it's remarkable how far they get, they get right to the cul-de-sac.
Stop
Yeah,
line,
right.
There's no issue with that.
Yeah.
Yeah, because it's a road.
But
It's
we
on the
don't
map.
need to make it wheelchair ramp accessible. Or do we?
No. Well, the other question then becomes, no problem with the stop sign and the stop line, but I think the question is, where are we talking? Are we talking from the, we've got the cul-de-sac of this development, and that it intersects with the further extension of Ricketts Pond Road, versus this was talking about going out to Spring Street, which is not within our jurisdiction.
All right, then if it's not within our jurisdiction. it's
Okay,
not
then
gonna
that's
be
off
allowed.
the table. then.
Yeah, we'll have to get rid of it.
You could still require a stop sign and a stop line at the, the entrance to this development where it meets Ricketts Pond, if you
Right.
want to make sure that folks slow down before they then enter the industrial park area. You could require that.
And a crosswalk. I mean, if they want to do a
Well,
loop.
again,
walking or-
I'm trying to remember, there's only a sidewalk on one side, so when you get to the mouth there,
It's on the.
are you connecting anything? And I
I
don't
don't
know
think
the
you
answer
are,
to
so-
that.
Okay.
I don't remember it on the,
No, I definitely know there's only a sidewalk on one side of the road.
down here.
Yeah, and anyway,
Yeah, it may not show. There's the line where we're to go through. Is this a sidewalk? No. I don't know which side the sidewalk is on. If you
it looks,
enter the 40B complex from the end of the Industrial Park Road,
Yeah.
is the sidewalk on the right or the left?
That's a good question. I'm not sure, so to speak.
Thought it
Yeah,
was
I don't have the plan.
on the left, but, Greg, do you recall what side of the road the sidewalk is on, or maybe Brad, off the top of your head?
I'm looking.
The industrial park portion of it?
Well, no, when you actually then come into
It's
the
on
development.
It's on the right side, driving in.
So if you're,
Southern side.
Okay,
South side.
all right, so it's going to be, so the sidewalk's going to be abutting lots 21, 20, 19, 18, et cetera, et cetera.
Oh, okay, that's this way here.
All right, so this is,
Road A.
all right, so this is the sidewalk.
Right.
Okay.
Okay.
All right, so in terms of having a stop sign here at this cul-de-sac, I don't really see much of what kind of, what real purpose it serves.
It's a
'cause
circle, yeah.
As a circle. If it were,
Yeah,
if it were an
and
intersection, obviously, yeah, that'd be a different story.
And there's no crossing, really, if there's no sidewalk.
I mean, theoretically, you could put a slow sign, but, it's very much a
But
polite
they're walking
suggestion.
into Carver, so there ends the discussion.
Yes. All right, so I suggest we cut out number 70, because it's, it's either not necessary or outside
Yeah,
the
it's
jurisdiction.
a nice to have, that's all.
Because they might choose to do it anyway.
no, they can do
didn't
it, it's their
volunteer
property.
it,
Yep.
so, you know.
Or maybe the HOA will want to do something, especially if
Yeah.
there's any accidents or something
As
happens.
soon as something happens, after the funeral, they'll decide to do it.
Yeah, that's sad, but.
I know, I shouldn't have
I
said that,
know.
but, it's the way it
But,
happens.
you're right. You're
I've
right.
been there and done that, so.
Right, yeah,
Okay, all right, so where are,
get it. We have a representative from the fire department, if you want to clarify.
Has it been since?
Just include
I
Where are we
think
now, Ethan?
we're better with adding
71, I
that
think.
line,
71.
I think.
Eventually.
and,
Okay, so
Adding more than this.
you have the answer. The sidewalk issue, if you want.
Oh, he has an answer.
Okay.
Okay.
So the sidewalk in the industrial park is on the same side, it's on the right side of the road.
okay,
But I guess it's not completely constructed to the cul-de-sac plan, but the Carver-approved plan shows it going up around the cul-de-sac. So there'd be some connectivity here.
all right. And I think that, we would want it to be connected so that people can have safe pedestrian access from the development to the road.
To Spring Street.
Yeah, to Spring Street,
Right.
the public way.
That's better.
Connectivity of the sidewalks.
Yes.
Which this development will then eventually continue that on the right-hand side, but you're not asking for a crosswalk of any sort, right?
No, I don't think it's that. It doesn't seem to be necessary.
Okay.
Yeah, 'cause there's no
Connecting
sidewalk.
Sidewalks, there's no need.
On
for-
opposite
There's no connecting
sides, correct.
sidewalks.
No, I don't see any reason why they should paint a crosswalk in nowhere.
Okay,
Okay, all right, so I think that pretty much covers,
so 70 is out, yep.
all right, parking, circulation, and traffic, signs at 72, Okay, at 73, there was a question of part, construction identifications and...
I don't know that we have seen any plans or suggestion about signs for this development.
Signage?
Yeah, we're going to have a monument sign or something that says, welcome to Ricketts Pond Estates, or,
Usually up to the developer, I would think.
oh, no, I know, just that we haven't actually seen
We
any,
haven't talked about it.
No, it hasn't been on
any
our docket
plans
yet.
for signs.
No.
Now, I assume that, signage has to follow our general bylaws regarding signs. I don't recall seeing a waiver about that in the list of waivers. I might be wrong about that, so,
I think there is something, but
All right, so-
we'll get to that.
Our sign bylaw doesn't contain, I was involved in writing the sign bylaw and enforcing it now, and there's nothing in there about, it's signage, like business signage
Yeah.
and illegal signs, but the traffic signage is, that'd be building department.
Well, no,
Highway
this
department.
isn't addressing traffic signage. This is, typically, these kinds of developments will have, for example, during construction, they're required to have signage that says, this is financed by, and sometimes they also put out, like, who is the main contractor, et cetera. But even after that, sometimes there is a sign that indicates, like I said, welcome to Rickett Pond Estates, to let you know that this is the homeowners association you are now entering. And we haven't seen anything to that effect here, so if they come back at some point with the signs, or maybe signs are not contemplated at this time.
Well, that's a good point, because we act as the planning board, and that's also with the planning board, for signage in that respect, traffic signage. There's got to be a speed limit sign in there somewhere. It would be nice.
Speaking of speed, there's no speed bumps called for in this, in this decision.
No.
All right. Okay, so essentially, who's going to approve the sign? If we don't know what the signs are going to be like, who's going to approve the signs?
Well, we can just say nothing about signs, in which case the applicant either then complies with whatever the sign bylaw allows, or the applicant would have to come back here to get approval of an appropriate sign.
All right, so why don't we do that? I think we should, just cut, eliminate 73 and let the waiver list handle that, if there's some relevance to it. Okay, so 74 and 75 deal with landscaping. There's a couple of comments there. And the highlighted section seems reasonable, but there was a request for clarification in the sentence.
Right, so typically you see a landscaping plan presented, and it would show you how the, entranceway will be landscaped, and it will deal with common areas, that sort of thing. We don't have that. We have just had some indication of street trees to be planted along the roadway. Do you want to see a landscaping plan? Do you not really care about the landscaping plan because these are going to be, 30 individual house units or 30 individual house lots? And, landscaping is going to be up to whatever each, lot owner chooses to do.
Or the HOA, because
Well,
HOAs sometimes can be really particular, but.
I mean, for example, let me put it this way, you have one homeowner who really wants to plant, say, apple trees in his yard. Now, but I think at that point, it would generally, may have some issues with that, And so I would think, generally speaking, the homeowner, the condo doc should be able to govern, what they can plant and where.
Okay.
That's
So,
what I think, too.
So I think, if it falls under, our general superintendence of, our general review, I guess you'd say, of the condominium documents, then I don't think we need a separate landscaping plan. If that makes sense.
Do you want me to just note, however, that landscaping shall be addressed in the HOA documents, or?
Yes,
Probably
do we
the
not
best
even-
way, because I
Yeah,
don't think
that's
we
good.
have control over who does what on their lot,
Yes.
unless it breaks a bylaw. If they pile junk cars up in excess of
Yes.
4, we can have them remove the
Yes.
5th one.
Or let's say they plant a tree right above their septic tank. That's probably not the best place to plant a tree.
Right.
Well, I did.
I hope the roots were shallow.
Oh, it's growing like hell, but they can do that.
All right, well,
Right, Jared?
Maybe the O&M says otherwise.
Yeah. Yeah, there might be something that they're restricted by where they go get a permit,
all right, then that's... Okay, 75, about mature trees, a tree preservation plan, and to protect the trees. That seems reasonable to me. And this doesn't require them to preserve any tree, though.
It doesn't require them to
Preserve
preserve
any-
any trees?
Yeah.
No, it just requires them to identify what trees will be preserved, and I think from prior discussions, there aren't very many trees to be preserved.
No, not from what I saw.
Yeah.
All right, so I guess that can stay in.
Then I think when we get to accessibility, 76, if we're not going to have any crosswalks, 76
Yeah, there's no point in
does
76.
not appear to be necessary.
77 seems okay to me.
Cut the tree, you have to plant it.
That's a good way to do it, too. I think twice. All sidewalks shall be ADA compliant, right?
Yeah,
Yeah.
I think that's fair.
Yeah.
Okay, all right. All right, general conditions, again, I think, this incorporates the waiver list. Okay, and 79 about the basin.
General bylaws. We're supposed to make our presentations, our decisions, based on covering the bases for, like, certain boards and committees that won't be involved with this, like planning board should not be involved with this, right?
That's right.
Right?
Then, general bylaws, I'm trying to remember what's covered under the general bylaws. It's
Well, like
waiving
wetlands.
that.
Wetlands, for example,
Okay.
is a general bylaw.
Yes.
Yeah, okay.
I mean, the applicant has requested waivers from both general and zoning bylaws. And as the comprehensive permit granting authority,
Okay, we can
it's our,
discuss
our power to grant those waivers.
Okay.
Let's see. All right, the basin, there's talk about a basin in 79. Okay, requires them to obtain an easement if required for access and maintenance. All right, so this says that Mass DOT is responsible for maintaining that basin, but the property owner, the applicant, and later the HOA, would grant an easement to allow DOT access to that if required, as I understand paragraph 79.
Right, we had a great deal of discussion about this at one of your last meetings, about
Yes.
the basin. And we don't have, applicants represented, there is no Mass DOT easement. Whether there should be or shouldn't be really is up to Mass DOT. They certainly didn't ensure that there was an easement prior to conveying the property to the current owner. But the applicant has said they're still willing, and they will pursue offering that easement to Mass DOT. If Mass DOT doesn't want it, then we should get some sort of documentation saying that it's not necessary, or whatever the case may be.
Now let us say that Mass DOT says, okay, we need an easement. Wouldn't Mass DOT have to pay the applicant some money for that privilege?
Perhaps.
All right. That can be left up to them.
Yeah. Yep.
All right, so yeah, I think that's fine. And let's see, 80 and 81. I think we already talked about the ADU. It says none. And
okay, there it is.
the structures, again, 10 feet. I think that's also covered within the waivers. No accessory structures in front yards.
Well, this is just going to any accessory structures, like if they put up a tool shed or a swimming pool or something. There is a different waiver that would allow, I think, up to 10 feet distances for certain structures that are shown on the plans, but, we don't know what any of the homeowners will ultimately want to put up as an accessory structure.
Well, and, to some extent, that would be governed by the condo documents as to what
Right.
is permitted.
Right.
I mean, I don't know how many of these units are anticipated to install pools on their property. Some of them might find it very difficult. Others of them would probably find it a little easier due to just the shape of the lots.
But they'd still have to come before, they'd have to get a permit.
Yeah, they're definitely.
Right, but it waives what we have now as setback distances currently.
You could also take number 81 out, and if there are any accessory structures in the future, then they either comply with the bylaw
Or they come before
or
us
Yeah.
to get,
Well, this makes it easier, because I think the bylaw is 20 feet, and this says 10. So I don't know where the 10
So
originated
essentially,
from.
all right, so essentially, we could, to the extent that requires a modification of a waiver approval, we could do with that, say, what's on the as-built plan can be 10 feet, but anything after that is going to be 20 feet.
could be, yes.
Because they need the 10, as I understand, they need the 10 feet to build their structures, and the statute gives us the power to waive that. But anyway, as terms of accessory structures, that is not necessarily required to approve a plan, to approve the plan. So I suggest that that's the approach we would take.
Good, good.
To keep this in, or just to remove it and just deal with what's been requested on the plan and the waivers?
Yes, if that reflects what I, essentially, what's requested on the waiver is, 10 feet from 10 feet from the lot lines for the structures that are going to be built.
Side and rear.
And, and then after that, then that's the waiver that they get, is the 10 feet on the as-built, and the bylaw applies to anything else.
Okay.
However we word that to make that in effect, that should be
Okay.
good. All right, so that takes care of the decision, because the remainder part is the record of the vote. But we still need to go through the waiver list, and I would suggest, because Suzanne
I'm
has something
just,
to do.
I just am working out getting her picked up so I can stay.
Okay, all right, so if we want to turn to the waiver list now, we can try and see if we can get through it this afternoon. And
But I would like to use the restroom.
Need a break?
yes, we might as well take a few minutes.
Yeah, I got it.
I don't want anyone to be caught short. So anyway, so let's resume with the waiver list. Thank you, everybody. All right, so anyway, so we have a final waiver list, and it's 23 pages. And so essentially, we'd like to get done by 3 o'clock. So the idea is, we'll go through them, and if any highlights or any suggestions are on there that we haven't previously considered in our final hearings on the subject, we can talk about them. So anyway,
You didn't resend the waivers,
The
though, right?
waivers were sent about
The other day.
10:15 or something like
Yeah.
that this
Oh, those
morning.
were sent
There were
as well.
some, I think you said 10:22 this morning.
Oh, the date on there too?
yeah, it should be.
It said again.
Okay, so it was separate.
6:25 at the top.
Yes, okay, good, thank you.
All right, so, you might want to go to page 1.
Do you think? I don't know why it opened at the end, that's
No,
weird.
no. All right, so anyway, the waivers start with let's see, general bylaw, section 145, earth removal, and there's a few highlights here.
And Mr. Chair, if I can again, I know I've said this to the board before. Based on your discussion so far, these are all assuming, some you have voted on and have approved, some you have not.
Okay.
I've drafted these based on an assumption that you approve, so you can then see the various conditions. If you deny any of these waivers, I don't want anyone to think that just because you see on the draft waivers granted,
Oh.
this board has not voted on all of these, and you could still vote to deny any of these waivers.
Okay, good.
Okay, so now, do you suggest that we go through either a single waiver or a group of related waivers and vote them up and down, or should we go through, and if nobody has any problems, we'll wait till the end and then vote on everything?
I think either way, I mean, you have already spent a good amount of time going through these one by one.
Yeah.
No new waivers are included. The only thing that's been added has been any of the proposed conditions that you've discussed previously.
All right.
So you might decide just to focus in on scrolling through them as anyone has a question, or anything that is highlighted that still needs to be worked out.
All right, we'll do what, I think we'll do what you just said.
Good question.
Yeah,
Jim,
yes.
Just one
Scott.
point of clarification. When the hearing was open, I believe you guys took votes on some of these.
Some of
waivers.
them.
Yes, we already
Yes.
did.
And if you were to change your mind, and it would cause an economic impact, would have no ability to put that evidence in because it's closed. So
Okay,
I just wanted to alert you to
Yes, on the
that.
ones that we already voted on.
do we know which ones we vote on? And which ones we haven't?
I do have a record of some of them, yes.
It would seem to me that most of the ones we voted on were probably more of the minor ones.
They
But
were the big ones, I think.
Well, you did have some conditions relative to some of the larger ones, too.
Yeah.
All right, but anyway, but for the first one on the earth removal, there's a lot of stuff there, and I know we talked about it, but I'm not sure if we actually took a vote on whether to approve it as written and it's been changed. So let's just make sure that if we need to make sure that it is what reflects our desires.
Mr. Chairman?
Yes.
On the earth removal issue, some of the material that's stockpiled contains stones and rocks and roots and things like that, and would have to have a little bit of limited processing to be able to spread the loam, because the loam was scraped off and still there, and we're going to respread it, but we would have to do a limited amount of processing, which is similar to what happens on any construction site, on any single-family home. You scrape the loam off, you dig the hole on the foundation, and then you screen the loam, and then you respread it when it's done. So we would love your consideration of that. if possible.
So essentially, you're talking about incidental screening.
Yeah, well, we have a lot of, some of the stockpiles are a large amount of rock,
Sure.
like yay big, that we need the ability to process, just to make it a marketable material that I can get off the site. 'Cause right now, I couldn't take it anywhere even.
So if you recall at one of our last two meetings, we did talk about the fact that the applicant has these stockpiles. They are within the limits of work as shown on the plan, and that some of that stockpile material either needs to be used in the construction on-site, or some of it may also need to be removed. So the applicant has also requested that we modify the condition, as you see, number 1, by striking the sentence that says there shall be no processing of earth removal on-site.
Okay.
And instead, it would read, the stockpiles consist of raw loam and rock that may be processed into a marketable material in order to remove it from the site, or reusing it on-site for landscaping, septic system materials, road base, etc. No new materials shall be brought to the site for stockpiling or processing unless intended solely for use on the site. We should probably say, for this project specifically. And then they continue, existing stockpiles not involving materials to be reused on the site may be removed as necessary prior to a pre-construction meeting.
And we hadn't voted on that yet.
No.
All right, so now, as I remember, when we were talking about the actual decision, we talked about no earth removal no earth shifting, whatever the word was, prior to a pre-construction meeting. I think that's what the actual decision said.
Yes, based on JDE's comments, yes, that some of, prior to any earth disturbance activities, the applicant needs to submit, their SWEP plan and some other materials, construction management plan.
Okay, because I just want to make sure it's consistent. So if we say, no earth disturbance construction activities prior to this pre-construction meeting, and that would conflict with the language I think you quoted me. So is this an exception, or do we require, that nothing happens till after the pre-construction meeting?
The only reason I'm asking for that is the most time-consuming part of the whole project is getting this earth removed from the site. And the only reason I asked prior to the pre-construction is, it would make more sense to have a pre-construction meeting when you're actually looking at building the road, utilities, things like that. And if you have a gap of, say, a year and a half from the first pre-construction meeting, then it really has no meaning when we go on to the utilities and everything,
Yeah,
which
I
is
get
more what Mr. Driscoll would be involved with in inspecting, drainage pipe.
You could also have a meeting specifically on this activity.
Yeah.
None of this activity will take place without a specific meeting separate in advance of the pre-construction meeting.
We could do that.
We could do that.
Yeah.
Yeah.
That way, everybody, everybody
do
knows
that.
what's going on.
All right.
Oh, that sounds good. Were there any other things that the applicant changed on the waivers?
Proposed.
Yeah, and we can go through them, because they've either been, they're either highlighted or shown as redlining. One of the only other change with respect to, it's not quite on this page yet, but number 4, where we were limiting the hours of operation, and again, this now has to be made consistent with the decision, because you just allowed some work on Saturdays.
7 to 12?
Yes, because I remember I saw it here.
Right.
Yeah. So instead of
But
7
the other thing is, I had added in that there would be no work on Sundays or legal state holidays. The applicant is also including federal holidays. I think that makes sense.
Again, yeah, I think it does. Okay.
And then, as you continue on, number 9, which currently just reads that no trucks associated with the project shall use High Street and Carver. Because if you remember, the applicant provided the earth removal permits from Carver so we could incorporate similar provisions. The applicant has asked that we change that to no trucks engaged in earth removal associated with this project shall use High Street and Carver. So in other words, if there is a truck that eventually associated with, a cement truck for pouring of foundations, for example.
So building trucks, okay, removal trucks, no.
Correct.
All right. Yeah, I don't have a problem with that.
Doesn't it
'cause-
say that anyways? It says earth removal. Number 9.
Number 9 currently says no trucks engaged in earth removal, associated with the project shall use High Street. I'm sorry.
I think
Is
the
it not-
reason, I think the reason it says that is because the Carver project was an earth removal project,
Okay,
and that's why
It's showing it that
project
way.
is in there.
okay. So is it a change?
So
or no?
so forgive me since
That is-
apparently my version is still showing that language as redlined. What you see up there on the screen is the language that is being
Okay.
proposed, yes.
All right, I don't think we have a problem with that.
Yeah, that's fine.
It's Highlighted number 12, permission from the proper authority in Carver, applicant shall repair any damage to Pond Drive or Spring Street caused by truck traffic associated with this project. That seems great. I don't know why it's highlighted, but,
It was highlighted primarily because recognizing that obviously the Plympton zoning board doesn't have any authority over anything that happens in Carver.
okay.
The Carver earth removal permits did require any damage to their ways to be repaired.
So that's essentially just a reference to that.
Exactly.
Okay.
Yep.
All right, so, okay, we talked about the conditions, so, all right, so, I have no recollection of actually voting on the earth removal, on the waiver conditions for earth removal. I don't think we would have done that because.
You wanted to see all of this.
You want to see all of it and the importance to the town, everybody recognizes it. So anyway, so do we want to vote, I think we've talked about this, at length. Do we want to vote on it now or do we want to just move on and vote on it when we're finished with the when we're finished with any other issues we find in the document?
They didn't give us a chance to offer any.
Whatever you wish to do. You've heard Attorney Galvin say that denial of some of these waivers, I don't know that all of them, but denial of some of these waivers may render the project uneconomic. And the public hearing is closed, so we don't have an opportunity to challenge that in any way. It simply would be something, obviously, for the Housing Appeals Committee to decide on appeal.
Yes?
This one also renders the project unconstructible, in addition to rendering uneconomic, because we wouldn't be able to build the project if we couldn't move this stockpile.
Sure.
We
Well,
thought we did vote on it because we would have put in the evidence of the economic
We
impact.
thought that's why you closed the hearing, because you voted on the waivers.
We don't
Well, we
have any
voted
problem.
on some, we didn't vote on all.
We don't have any problem with
Well,
you
they're modifications.
finalizing the language or making a decision at all, but the concept of, we thought was done.
Well, I think that would be, I think, I agree with them that, if we voted to deny the earth removal permit, that's essentially denying the permit itself. So anyway, so why don't we make it easy and take a formal vote on the earth removal bylaw waiver now and get it out of the way. That's not to say, that doesn't mean that the whole permit is approved, it's just that we say that this is what, that in terms of the waiver, this is what we want to grant. And if there's any issues regarding that, then they could raise it with the Housing Appeals Committee. I don't, but I think these conditions here are reasonable if we're going to grant this permit.
Can I just ask a quick question, too, before we do that? So in terms of the case that they have ongoing with the town,
I'm glad you mentioned that.
is that related to any of this with the earth removal? Like, are we negating what's going on with the town if we say, okay, yeah, we can grant this waiver?
So as I've said before, no.
Okay.
What you are
It's
allowing.
just related to
Yeah,
the
I mean,
concern.
there's, whatever happened previously, that's the subject of the litigation.
Okay.
Looking back. This is going forward in order to construct
just
this
for the
project. Are we willing to allow, these deviations from the earth removal bylaw itself? But also, remember, you act in place of all local boards, so you have to grant an earth removal permit, just like you're granting essentially, a well permit or street opening permit by virtue of this decision. So we're not forgiving or overlooking anything that may have happened to date. It is just allowing, we've got the site in the state that it is in, and that'll ultimately be between the select board and the applicant and perhaps the court to figure out how it got to the state it was in, or whether it was in compliance with the bylaw or not.
Okay.
This is moving forward. That yes, the only overlap I really see is with respect to the stockpiles that are on the site.
Because currently there is a restraining order in place preventing any movement of those stockpiles. If we grant this waiver and grant the decision, we will in effect be allowing them to move that stockpile. And essentially, if I remember reading the decision, essentially that restraining order remains in place pending action of either the Board of Selectmen or this board granting some kind of permit. So essentially, they will be able to have that restraining order removed to the extent that we allow them earth removal activity.
So that, in a nutshell, says that we're acting as the Board of Selectmen.
Yes.
Correct.
In that case.
Correct.
All right, now I understand. Thank you, Suzanne.
And that's why I was suggesting no activities take place until there's a meeting specifically for the earth removal.
Okay.
And we'd be
Yeah.
okay with that.
Okay. So
Yes. And so that's definitely adding,
Okay.
we'll definitely add that into the waiver condition.
Okay.
All right, so anyway, but getting back to my procedural point, I think it would be a good idea to vote on whether to grant the earth removal waiver to formalize it. And again, that's granting the waiver. That doesn't, we still need to have a final vote on the actual decision. So it's still not triggered until we actually vote on the decision to grant the permit as a whole. Is that correct?
Correct.
Okay.
All right, so anyway, so let's do this in the formal way. All right, I move that we vote to grant the waiver of Chapter 145, the earth removal bylaw, as indicated in this waiver list and as discussed this afternoon. Do I have a second?
Second.
All in favor? Aye. All right. Okay, so that takes care of that section.
Excuse me, was that unanimous, Mr. Chair? Just want to
Yes,
make
it was
sure.
unanimous.
Okay.
Okay, the next section deals with schedules of uses and lot setbacks. Okay, let's see, I think 300-5.1 is the first one, where there may be a, okay, that just says that lots,
So no waivers needed in that.
Right. This is just with respect to E. That it's all lining up there. But
Or maybe the next.
E was the maximum percentage of impervious coverage of land, which in the industrial district is 60%.
that says 30%.
Well, that's just maximum percentage of land covered
Okay.
by buildings.
Okay,
Scroll down to E.
on this next page.
and
How's the E on
E has been removed, which is fine because
Granted.
the way, we determined that a waiver was not required,
Yeah.
so.
All right, but what about D? It says, it says maximum percentage 30%, and it says D 7% for lots 1 through 7, so we don't need a waiver for D, if I understand that correctly.
Well, we should probably just clarify with the applicant, lots 1 through 7 do not need a waiver? Or are we saying that lots 1 through 7,
We don't need D.
you don't need D either?
Because we comply.
What we say is lots 1 through 7
Already
are on the
compliant.
maximum for the project at 7% per lot. So we're well into 30.
Okay, yeah, that's what
Okay.
I'm saying.
Okay, so you don't need D or E, okay.
D granted, so that's fine.
All right, so side yard, okay, right, they're asking, let's see, looks like they're asking for an exemption from A, but I'm not sure about B.
So, right, so B, I think, is still in question here for, we certainly understand A, because of the 75-degree at the street line. B, we're still dealing with the agricultural residential district and not being any closer to 50 feet of any sideline. The agricultural residential district, though, is in Carver. And I understand that certainly you need the waiver under A for the 75-degree at street line, but it still is not clear that you need the waiver for B.
What says here, applicant to clarify the need for waiver, but they do need it, or?
Well, as I said, we meaning JDE and I looked
Okay.
at this, and we thought that there was no waiver needed for B. The response the applicant provided was yes as to the 75-degree issue, which I understand, but that's A, that is not B.
Okay.
I'm not clear on B. I'm not, I guess.
I think it might be best to withdraw it then, or just not to grant it. If it's not required.
Just
I
eliminate
mean,
it.
it doesn't affect the project in any way, so if it doesn't, I mean, if you grant the waiver, then,
I suppose one option is to just withdraw it since we can't quite pinpoint why it would be necessary.
Why we're waiving.
Another option would be, to the extent applicable, are we willing to waive it? Again, there's,
the project is shown on the plan.
All right, I can do that for B. Again, it doesn't sound like it's a real issue, because it is in the industrial zone. And it doesn't appear to be abutting a Plympton lot in the agricultural.
right.
All right, so let's continue with the section goes up for 3 pages, but let's continue on the section, and then we can vote on them as a whole if there's any other issues. Okay, yeah, retreat lots. Let's see. B says no waiver required. Applicant to conform.
Right, so on this one, this was one where the applicant's note was check whether a waiver is needed from B,
We don't need it.
not needed.
Yeah, that's withdrawn. Okay.
So you'll eliminate that?
We'll eliminate that one.
All right, so G was highlighted, and I had a question, and I had a comment about G. Because we just talked about, before the break, the 10 feet from the lot lines. And I think we said that we grant the waiver as to the structures on the as-built plan, but for accessory structures built thereafter, we weren't going to waive it.
So we could say that the waiver is granted with respect to the structures shown on the plans.
Okay.
Could go further to say accessory structures shall comply with the zoning bylaw.
Yes, I think that
That's good.
reflects what we,
What
our
we
thought.
just, yeah.
All right, so, all right, the next one off for off-street parking.
And didn't we take care of that, pretty much?
I think we did, I think we did.
And that's why they added the extra parking, and
Yeah, so the driveways.
and we already
20 feet.
granted it.
Yeah, I think we did.
12 and 20.
All right, again, before one driveway, switch one garage space.
Waivers not required.
Okay, and C3, we have a visitor parking area.
Yeah, we
So,
granted that.
okay,
Waivers not required. Are you just doing the highlighted?
yeah, I think so, unless, because if it's not highlighted, then I think we've already looked at it.
We've already gone through it, yeah.
Let's see.
So it says waivers are you down the same way?
Yeah, with the section on special permits, it says.
Dave, you gotta go down a little further.
What were it's 9?
Keep going. The next one right here.
Yeah,
Yep.
special
Article
permits.
7.
All right, so, it says waivers
Waivers not
not.
required
Under 40B.
as of right zoning requirements.
I'm not sure I
Yeah, what does that
understand
mean?
the second sentence.
So under the 40B regulations, and specifically the provision that's inserted there, the applicant only needs to request waivers from as-of-right zoning requirements. They don't need to request a waiver from any special permit requirements.
Yes,
Sometimes applicants do it, put the request for a waiver in out of an abundance of caution, but it is not necessary.
okay, yes, I mean, because I feel that paints too broad a brush. I mean, that, if you grant that to its logical extent, that means you could put things like kennels on there, or daycare centers, or whatever else we put a special permit on there for. So I think that should not be, waived.
It should just come out.
Yeah, just come.
Yeah.
If there's something specific, obviously, that's something we could address, but it has to be on the list. Okay, and, all right, that language is also repeated on the next page. And, the same thing that should happen there.
So under, maybe if we could scroll back up a little bit for groundwater protection district relative to F11.
Okay.
I think the applicant needed some sort of clarification here as to what was happening. So F11, under prohibited uses, which I think is, yep, you can see it up there. So the permanent removal or regrading of the existing soil cover resulting in a finished grade within 10 feet of the spring high water level, except for mining as permitted by the Board of Selectmen, or except as necessary for agricultural purposes. So that's a prohibited use in your groundwater protection district. I think this was something from a recommendation from JDE, but sure Greg will clarify that, was to say what you see, which is that the waiver would be granted only with respect to areas to be regraded adjacent to isolated vegetated wetlands as shown on the plans. So I don't know if, Greg, if you recall what was behind that one, because the applicant has said Obviously, they're not going to, they're going to adhere to the 25 no-touch zone. I revised the waiver so that you see the language up there to say that it's granted to allow the regrading adjacent to the isolated vegetated wetland as shown on the approved plans. But if something else was actually intended, I think we need to clarify that.
And I think referring to the plan is fine. They show.
So you're okay with that language as shown up there? And does that address the applicant's concern?
I think it needs to extend to the entire site, because we're not quite sure where the ground, just because we excavated, I don't know, 20 test pits. There were only a few that we encountered groundwater in, but say on some of the lots where some of the septic systems are, it's possible that the septic systems would be within 10 feet of the water table. Requirement's only 4 or 5 foot separation. So we're not quite sure. My point is that we're not quite sure where the ground, we know it's deep, it's relatively deep, we just don't, we're not exactly sure where it is. So there could be other areas of the site that are within 10 feet. So,
That would only come into play for septic, though, right?
It's not just grading, it's more.
For detention
I'm not,
basins?
well, it's stormwater basins as well, yeah. There are actually stormwater basins that are proposed that are near the isolated vegetated wetlands that I know they're probably within 6 feet of the groundwater table.
With respect to the 25-foot horizontal, yeah, plans cover that, but that makes a point for the vertical.
Right, so should that just be a recommendation that the waiver be granted? Okay, so that is the recommendation to the board.
All right. All right, so the next page, I don't see anything on there except for 16 seems to be added, and we already addressed that in the prior section. So I think that pretty much covers this section, which deals with the general bylaws. Yes.
I think F15 is similar.
Okay.
Language needs to be similar regarding the 10 feet. So the waiver just needs to be granted there as well.
Okay.
The same requirement, really.
Okay.
Wasn't hard.
So if I understand it, one of the main issues is the 10 feet to the historical high water groundwater table, and you're saying essentially that the state standard is 5 feet, or something.
Septic system.
Okay.
Septic system.
Septic.
But what I'm saying is, we're not quite sure in all parts of the site where the groundwater table is. So, I mean, we very well could be within 10 feet in some areas. We will be, we know, where the stormwater basins are.
So wouldn't that be governed by Title V then?
No.
Okay. So what?
This condition doesn't have anything to do with Title V. This is from your bylaw. So, I mean, this doesn't pertain to septic systems, this particular requirement.
Okay. That's just an example.
An example would be, yeah, like,
Or even put a foundation in, so you're talking about digging.
yeah, we could very well be within 10 feet worth, with a foundation, because you're 8 feet below ground surface, and so.
And you'd still be following the state regulations, right?
Well, there aren't really state regulations
Oh, there isn't?
on separation of groundwater other than for septic systems.
Okay.
But there could be, but nothing come to mind.
By the way, foundational question, maybe Greg can answer it. Are we certain that their property is within the groundwater protection district?
Whole town is, isn't it?
I'm not sure what the boundaries are, and
I think it's town.
okay, you might be right. If I was able to get Mass GIS up quickly, I could probably tell you, but I don't feel like it.
It's not the whole town, but the site is, there's a map in the zoning office.
Maybe I'm thinking of Carver.
Okay. All right, well, we're, obviously, if it wasn't, then the waivers wouldn't apply, but in this case. All right, so I think we're, again, do we have, what Brad said about about number 15, do we have, we would make it similar to what we already said about.
Right, 14 above.
11.
11. All right, so with 11 and 15 essentially waiver granted, I believe that's the change that's being proposed. All right, do we want to take a vote as to this section to approve it as we've discussed?
Okay, could do that.
All right, do I have a
That's all
second?
here.
Second.
All right, all in favor?
Aye.
Aye. All right. Okay, all right. Okay, next section is Chapter 290, Wetland Protection. I don't see any changes there. And again, for subdivision regulations, I don't see, there is something. Okay, there's one change there's one red point on the subdivision regulations.
Yeah, and just see.
Okay, all right. Now that's
Don't
page
Need a
9.
waiver, yeah.
I think
But what about the
wetland protection.
wetlands were first?
Oh, yes. I didn't see any.
I thought we went through that already.
I think we didn't see any changes from what we previously considered. So,
Because it,
if we want, we can take a vote as to the section.
because you said the waiver was already granted. Didn't we vote on this already?
You reviewed them. I don't have that you voted on the
Oh, okay.
wetlands.
All
No.
right, so unless any, so why don't we take, we'll do a vote section by section after any questions and comments. How about if we do that as operating procedure for this
Yeah, that
document?
works, yeah.
Okay, wetland protections. I don't see any changes from what we previously considered, and so I would entertain them. All right, so I would vote to approve the waivers as granted in this section. Do I have a second? All in favor? Aye. Passes unanimous. Okay, all right, now, subdivision regulations, the next section, all right, so on page 9, we had a change about C. All right, so it says an exempt, they need a waiver, computation of runoff, if I read this correctly.
Could we go back up to 3.4?
Sure. Okay.
So the very beginning of it was fine, and then the applicant wanted to add in, and I'm just looking to see, where it begins, percolation test shall be performed on every other or every third lot. Keep going, keep going. That next line, it begins.
Next?
Nope,
Oh,
nope,
okay.
nope, go back
Up.
up. The sentence, nope, go back down. The sentence that's, looks like it's 5 lines up from the very bottom. It says percolation test shall be performed
And every,
Third lot,
on
yeah.
every other or every third lot shown on the approved plans
Oh, the new soil.
to confirm the
That
native
seems-
soil material, sand material.
That'd be every lot?
This was something that the applicant questioned where this came from.
I think that was in one of my letters.
Yes,
And I
so,
worded, that was my recommendation, have it done during the permitting process.
That's what I said.
yep. So is that something that at this point is still necessary, or,
No.
so we could take out
They
that?
approved, and they're gonna be doing perks for septics on each
Right,
lot.
right, that was earlier on in the process.
That was my comment.
So that would come
Yep,
out.
so that sentence beginning with percolation, although you still want the last sentence that says, "The applicant shall provide copies of all perk testing reports to the Board of Health and ZBA."
Yeah.
So you do want to keep that in?
Yeah, we'll keep that.
Yeah,
Yep,
yep.
All right.
so that could come out.
Okay, so what would be the next change that we need to consider? Was it 350-5.3B?
Yes.
All right.
All right, so this one's going to require a bit of an explanation. Let's see, because it talks about computation of runoff. I don't understand why they need a waiver from it.
I can explain,
Go ahead.
if I'm allowed to.
Oh, sure.
Yeah.
There's a requirement that the hydrologic analysis assume the development of each lot to the maximum extent permitted by the zoning regulations, which in this case is 60% lot coverage. It's not something we did.
Okay,
That's why we need the waiver.
all right, so,
We assumed a certain, what we assumed is what you see on the, that's what we assumed for impervious coverage is what we showed on the plan,
okay.
which is very close to what will be constructed.
All right, so your computation of runoff is based on what the plan shows as opposed to that 60% figure that you
Correct.
mentioned? Okay.
So I would have driven the numbers way up
Yeah,
as far as the,
yeah, no one, I mean, that's a pretty crazy requirement.
So if I, all
Commercial project, anyway.
right, so essentially, what you're suggesting is that, that your impervious coverage is lower than the 60%?
Much, it's like
20.
half that.
All right. All right, then I don't have a problem with that waiver. Or is waive to the extent that, that they calculate according to the area shown on the plan, however you. word
Project
that.
shown on the plan?
Project shown on the plan.
Okay.
Right.
All right. Is there anything else on this section that we haven't seen before? I don't look, or that there's questions about, because I think we've pretty much gone through this in the past.
Yeah.
No, I think the rest of the subdivision regulations, there was, if we scroll to 5,
Fire protection.
yeah, 512 for fire protection, there was a change made to indicate that the cisterns would be 25,000 gallon cisterns, but we've already addressed that.
Okay.
Yeah.
All right. Okay, all right, so that covers that section, so I would move to approve the waivers in that section as written and as discussed. Do I have a second?
Second?
All in favor? Aye. Okay.
Unanimous.
So now we have Title 5.
All right, so going on to the Title V regs, there's a couple of, there looks to be a couple of things on here.
So the colorful highlighting you see at 15.211, it's not a change, it was just highlighting from a prior draft that the applicant had submitted. We'll remove that highlighting, but it is not to denote a
Okay.
change.
Okay. And on the next page, there's a couple of highlights.
I didn't see any.
Private water supply?
If we could go, my apologies, if we could go back up to 15-203.
Okay.
And this does not,
Nothing here?
it is not being shown as highlighted on your version. JDE had suggested a change to the language that was shown, still granting the waiver.
Let's split up the responsibility between JDE and GEI on some of the reviews.
Right, it still kind of captures the original language, but it did elaborate a little bit on it. So I don't think that's a substantive change, just wanted to bring that to everyone's attention since you might not have seen it since 10 o'clock this morning.
Okay, now, one observation, we include, obviously, I know that JDE is going to be the board's designee and overseeing the applicant's compliance with our various conditions and such. And also this, I'm not sure if I actually saw JDE mentioned in the actual decision or not. It's a lengthy document. But anyway, this is incorporating GEI into this process for this for some of the Title V activity. So are we, now the applicant's responsible for paying GEI for their services.
Right.
You have a condition in there
All right, so-
that requires us to continuously pay.
All right, so,
I'm not sure why do you need GEI involved? If you have someone like Greg involved, you're reviewing the nitrogen loading calculations, which is relatively easy. It's not something you would need a hydrogeologist to do.
Like it says, for consistency with the hydrogeologic assumptions in Zone 2 groundwater protection analysis, the line decision, because you guys are going to have further hydrogeo drilling and stuff like that done.
With respect to the well testing, the well test condition, yeah, the well testing condition.
It's kind of tying back to that.
all right, so that seems to be in order. And yes, so that JEI will have a continuing,
If I could just interject.
yeah,
Their only involvement really is, to review the initial well test. One of the conditions for the IA technology, the waiver, was to incorporate their suggestions about the testing of the well, drilling, and before any construction is done, drill the well, get the testing results. So beyond that, I'm not sure why you would need GEI on an ongoing basis.
I think it's just closing the loop on this portion of it, where it ties back into the nitrogen loading and consistency with the hydrogeologic assumptions and Zone 2 and all that. So.
What's your concern with having them involved? The expense?
I think it probably needs to be, this probably is too vague, this statement, the assumptions. I think maybe it should refer to the conditions in their letter, rather than have it be open-ended.
Okay.
Because they have
With
specific
respect to that
recommendations in their letter.
Right, and that's referenced in other waiver conditions. But are you asking that it be referenced with respect to that?
That paragraph
That
about
last-
GEI, yeah.
Well, GI is also mentioned above in the last two paragraphs, so
Septic submission, what else?
we've got the hydrologic peer reviewer, GEI, who shall review.
Yeah, I don't understand that condition at all, because GEI, this implies that GEI, does this imply that JDE and GEI are going to review every application for a disposal septic system for every lot? Rather than the Board of Health? I guess that's the question.
So would the Board of Health be doing that?
I think it's really,
It's a Board of Health functioning.
yeah, and it's,
And the Board of Health would still be involved then in this?
Definitely.
I guess it's up, does the Board of Health feel like they need a peer review for every septic system design? That's the question.
It's
Because that's-
reviewing the proposed nitrogen removal IA systems that you propose to use, once you zero in on the final IA technologies you're going to apply to the project.
We'll use the same technology, there'll be probably the same technology for every lot.
Yeah, so it would be a review of the ones that you've
So I was thinking
zeroed in on to
maybe
use.
next Monday or the Monday after.
Say that you have two different
Because we
systems,
gotta
you need to review
finalize all
those.
this
and-
stuff, and I don't wanna be rushed, but I wanna go.
How about prior to the first septic system
Because I
permit?
wanna bring up this stuff.
That might
It's
be
really
what-
just reviewing the selected
Yeah.
technologies that you guys
Like
come
We,
up with.
we want you to do that, so maybe
Yeah.
prior to the first septic system permit, they'll review it, and then, because we're gonna use the same thing
Yeah,
throughout.
Let's go
Then
next.
they're approved for use throughout the.
Right.
Oh, no, Monday would be too
Uh,
quick.
Yes, Jared, did you have it?
I think because this is a new septic technology that we're not reviewing on a regular basis, I think we would like some technical assistance. Right. And I think maybe we would want Greg's involvement, and especially because of the volume of work. So it's something new to us, and it's a lot of it.
I think that would be a decision by the Board of Health on their own, separately, once you get the applications submitted to you. You could then reach out to us, engage us directly to your board.
Okay, so I would have to, I'm just kind of speaking out loud for what my thought is. I would have to speak with the board as a whole about that. But,
A moment, Jared. Did you post a meeting for?
Yes.
Okay,
Yes.
all right, go ahead.
So, yeah, I think it would be something the entire board to discuss on how to move forward, but that's just my immediate thought is it's a lot of material or a lot of work to do, and it's a new system for us to review. And I think we probably would like some assistance.
All right. Okay, so what changes do we need to make to this section? You know,
It's the same technology, right?
if we need to make any. I may have lost a little discussion.
550, 1 for 660.
I mean, it seems complete.
So if what is being suggested is that prior to the issuance of the first septic system permit from the Board of Health, the applicant's going to identify the technology to be used, and JDE is going to review. I think that's fine, provided, and thank you for enlarging that. I think that's fine, provided it is the same IA technology used throughout the project. I think if, for some I know you've indicated you're not going to change technology. If you change technology, then the first permit for the other technology should also be reviewed.
Yeah, if we substituted a different technology.
Exactly.
no
Yep,
problem.
yep.
That's fine.
So you
And
can
then we'll have to
reword.
identify two different technologies, one to treat by 50 gallons per day and one for 660.
We'd be okay with them reviewing both or any substitute.
Okay.
All right, I want to make a proposition because I need to go. Already stayed much longer than I had planned. Is there a way for us to, because I know the vote has to be done by July 7th, is July 6th an option for us to get together to just get these final, done, finalize it? I mean, we're pretty much there, but I don't want to rush through. I'd like to make sure that everything's articulated, and does that work for you guys? The 6th? So it's
Well,
after the holiday.
I was going to say,
but-
first and foremost, defer to the board, because you've got to be able to get the three of you.
Yeah, are you guys available on the 6th?
The 5th of
July.
July.
Because it has to be voted by the 7th, and I just
Yeah,
thought
we
it'd
have
be
a
nice to
drop
get
dead
this.
date somewhere.
Drop dead date is July 7th.
7th, right, so 5th would be,
No, she said July 6th, which I
July
believe is a
6th.
Monday.
yeah, I'm okay with
Yeah,
that.
let's see, do I have anything on July 6th?
And that way we have it all written out, we can just, it
Yeah,
won't be a
yeah.
long thing, but we'll have this
Okay.
all clarified and then we can.
All right, so yes, I can review on the 6th. Let's see, the selectmen have their meeting at 1 o'clock, I think. I'm not sure if that's a meeting week or a non-meeting week.
Well, if they do it at 1, I mean, we could do 6 o'clock.
Yeah, we could do it later on the day.
You want to
Yeah.
do that?
Later in the day? Oh, yeah.
Does that work for you guys?
During the day?
No,
No,
it would be, because
6.
there's a meeting already that day. I mean, I could do earlier. I'm like,
4 o'clock?
I could do 4 o'clock. Does that work for the room?
Yeah.
I can do
Yeah.
4 o'clock. Even better.
On the 6th.
I wish I had more time, but I've already spent much longer than I had hoped.
Okay. All right, we can move to adjourn. All right, are we set on can we, what, if there's, is there any other changes that we need to consider for this section, or are we set, or can we stop at 203?
I think we can stop at 2:03, we can put some of the language together, and hopefully there's an opportunity to have other folks review it
Okay.
before the 6th.
All right,
That would be excellent.
okay.
You want a motion to, or can I motion?
Yes, you can.
And I make a motion to end the meeting.
All right, so motion to adjourn, all right.
Motion to adjourn.
Is there a second?
Second.
All right, all in favor?
Aye.
All right, thank you very much for coming. We'll see you again on July 6th
See you
at
guys
4
on the
p.m.
6th,
6th at
4 p.m.
4 o'clock.
p.m.
Have a great holiday. Take care.
Thank you, Suzanne.